to welcome all of you on behalf of the Northern Regional Committee of ICAP to this session, Competition Law in Pakistan. Before we delve into the enriching sessions and discussions lined up for the day, let's commence our program with the recitation of few verses from the Holy Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين.
Jazakallah. Following this, please rise for the national anthem. Have you ever wondered how the rules of competition had shaped our economy and impact our daily lives? How fair play in business can drive innovation and protect consumers? So you are in the right place. So welcome to this exciting seminar on competition law in Pakistan. Competition law might seem like a complex web of regulations, but at its heart, it's about creating a level playing field for the businesses to thrive, innovate, and serve their customers in a better way. So now let's kickstart this remarkable session with some brilliant opening remarks. So we are privileged to have with us today a distinguished individual whose diverse expertise and remarkable achievements precede him. A fellow chartered accountant and ACCEA, he brings to the table a rich blend of experiences, currently serving as a distinguished member of Competition Commission of Pakistan. So without any further ado, let's extend our warmest welcome to Mr. Salman Amin. Please join me in welcoming Mr. Salman Amin. In your applauses. Over to you, sir.
Thank you very much. Assalamu alaikum and a very good afternoon, Lahore, Lahore ICAP. Uh, this is, the series of events which we had uh, planned with the council, ICAP council. ICAP council came to our office and met, and we perhaps agreed that we should have more capacity developed of ICAP members as well on competition law. And why not? Competition law by all means is, very core to every economic dimension of this country. And the challenges which we are facing right now, whether deceptive marketing, or when you talk about finance and when you talk about merger and acquisitions, I think CA firms are leading when it comes to advising their financial clients on merger and acquisition, what sort of challenges which they face in merger and acquisition, and why we want to foster the competition in all sectors of the economy. Related aspect is there are certain exemptions which we also grant, which is not in the knowledge of many people, but there are certain very strict criteria on which we provide the exemption. And foremost, I think the most of the questions which we often get to see is regarding the cartel behaviors. If you are closely following, internationally and locally as well, now we are having the challenge of international cartels, not only the local cartels, the international cartels. And then with, more and more advancement of digital platforms, there is so much of, we have so much of vigilance to do, that we have to establish an MIU, Market Intelligence Unit. And this is something which has not been sort of introduced by us. All the regulators in the region and globally, they are also going towards MIU. And MIU is really focusing on what is going on the digital platforms. And a very new dimension of MIU is coming when it comes to AI, that there's a deceptive marketing, and then you try to figure out, and then you came to know that's an AI generated image, or this is AI generated, or these things. And then State Bank is also consolidating certain things in the banking sector. In privatization, we could see certain transactions being carried out. Recently, you might have seen about the PIA. We have granted the approval when it comes to the telecom sector. Right now, we are going to get into the phase 2 of this PTCL request for acquiring Telenor. So all these things are very core to all of you and all of us. Regardless of being a CA or not, you are a consumer as well. There are certain practices when it comes to deceptive marketing which you have to handle, whether you are CFO, or again, you are when you are chief regulatory officer or risk officer, there are certain aspects which you have to look. And I'm also pleased to share with you, and I'm grateful to Mr. Ali Latif as well, that who had earlier agreed with us that the ICAP, this director training program which is being held under the auspicious of ICAP, that would also include a competition module. And the same we are doing with IBA, the same we are doing with PICG. So ICAP is also part of it. So now the DTP, which is going to be held under the ICAP, is going to include the competition law. And I won't take much time, because we have got very learned panelists. And I would especially like to thank Mr. Zishan Ijaz, the Vice President. We have earlier coordinated on various other activities, but this is the first time Zishan Saab and I have coordinated on this competition law, and in his home pitch, on his home ground. So thank you, Zishan Saab, for inviting us and for honoring us with this. So I look forward to active participation from all of you. And thanks a lot, ICAP, for inviting us. And I look forward to a very good session. Thank you.
Thank you so much, Mr. Salman Amin, for sharing your opening remarks. So let's formally start our session to shed light on the competition law in Pakistan. And we are privileged to be accompanied by the Director General for Competition Policy. He began his career with the United Nations and also worked with the World Bank and the Asian Development Bank. Among his many achievements, he served as the project manager of anti-money laundering program by SECP. So let's welcome Mr. Ahmed Qadir on the stage. Please welcome in air applause, Mr. Ahmed Qadir. Over to you.
Sir, thank you so much for your welcome remarks, and wonderful to be here in front of ICAP. Last November, I was in the ICAP office in Karachi, so it's a pleasure to be here in Lahore also to meet with uh, people of the profession. Before I start, there's a 3-minute video that I'd like to show you, and it sort of explains a little bit about the competition law and sort of sets the tone for the rest of my presentation.
From barter-based economies to the technologically advanced stock exchanges, trade has been the lifeblood of civilization throughout human history. The market serves as the cornerstone of the modern economy. It provides a platform where buyers and sellers meet for exchange. It distributes wealth. It redistributes resources for the most efficient firms. It provides a platform for price discovery and liquidity. In a free market economy, prices of goods and services are determined by the forces of supply and demand. With the rise of free commerce, mafias and racketeers engage in profiteering, market abuse, exploitation, and fraud. The evil powers have evolved into a more complex form in the modern world called the cartel, monopoly, and duopoly. Cartels earn unfair profits at the expense of ordinary citizens. The examples of cartels are when business rivals join hands to fix and regulate prices, fix the quantity of production, distribution, or sale of goods and services, rig bids, limit output, or split markets to profit illegally, apply dissimilar conditions to equivalent transactions, require other parties' acceptance of unrelated supplementary obligations for contract conclusion. Consumers pay the cost of cartels and mafias. Cartels choke free markets, impeding prosperity and national growth. Taking action against cartels improves sector and economic efficiency, removes entry barriers, and ensures affordable product availability for consumers. Competition laws punish cartels, forcing their members to break free for business survival. From nationalization to privatization, Pakistan's economy is dominated by a select few major players who influence various sectors. Competition Commission of Pakistan has uncovered cartels in sugar, cement, paint, telecom, energy, banks, automobile, poultry, wheat flour, and edible oil sectors. Several other investigations are in progress. CCP's performance? 145 investigations, 58 dawn raids on cartels, 157 orders, 74 billion rupees fines, 1,078 mergers, 43 policy notes and opinions, and 21 research studies. The CCP encourages whistleblowers to report cartel activities. Individuals offering substantial information about cartels may be eligible for rewards up to 2 million rupees. If you have information about cartels, contact us at 051 111 111 229 or WhatsApp number 0304 087 5255. You can also send us an email at complaints@cc.gov.pk or miu@cc.gov.pk. Your input is crucial for maintaining fair markets.
So, rather than a complex web of regulation, ये pretty basic, market का जो impact है, productivity, resource allocation, efficiency, these are all terms that we as common business people, as professionals, as people who are into the market economy, we understand these terms. I noticed abhi Zoom pe there are 25 online participants, so I'd like to welcome all of them. I can't see them, but I hope that they can see me. And I'd just like to start with my slides for today. So, competition law and consumer protection in Pakistan. We'll just go through the background of what the Competition Commission does, the competition law, and the certain element of consumer protection that we have under our law. Just a brief outline of my presentation. We'll talk about competition in the market economy, Pakistan's competition law. We'll look at prohibited agreements and what is this concept of abuse of dominant position. We'll look at mergers and acquisitions and something about consumer protection, which is deceptive marketing. And then I'd like to close with some practical guidance to the accountant's profession. And then we'll conclude this presentation. So starting off, what is competition in the market economy? So competition is basically rivalry between firms in the economy to gain you as a customer. And when companies have more customers, hopefully it translates into a higher quantum of profit for them. And then in order to keep you as a customer and in order to patronize your services, they will hopefully innovate and give you value for money. The presence of numerous firms in the market is helpful because it allows prices to stay somewhat stable and within a certain range. So you're pretty much aware of, the aspect of competition when you have price stability in Pakistan. But why is competition important, and why do we hear this word, competitive economies, not competitive economies, etc.? So when you have competition, it ensures some sort of rationality when companies price their products. Okay. A competition actually favors the consumer because it gives you products and services of a certain quality or of certain price points which suit your purchasing power. So there's a range of goods and services that you can acquire. So when you go into a mobile shop, you'll have something starting from 10,000 rupees going all the way to 700,000, which the high-end smartphones are. So that is what competition does. It gives you value for money. Competition in a broader perspective favors the creation of new business because the price mechanism signals to consumers and to business people that, oh, this is a sector where they can enter. And competition, we'll just return when the lights are back. So competition promotes innovation, and the process of creating new products, new goods, new services is a hallmark of a very competitive economy. And overall, it's beneficial to the country's whole entire economic profile. More competitive economies have more turnover, more innovation, more dynamism, more startups, more large industries, all the way down to smaller industries. So that dynamism is something that is encouraged by competition. But what generally happens, and this is something to do with human nature, behavioral economics. So when Adam Smith said in 1776 in his very famous book that people of a certain trade cannot help but get together, and that discussion ends up in a conspiracy against the public, meaning that people would rather collude than compete. So that's something of human nature that he tapped into almost 300 years ago. And coming closer to our times, Joseph Stiglitz, the Nobel Prize winner in 2001, he said, although competition is the basis of the market economy, firms try their best to restrict it. And rather than competing, they'd rather collude. Again, echoing what Adam Smith said. So what should the government do? So it has to set the rules of the game. And this is where the regulatory state or the regulatory frameworks of most countries come into play here. And in recent years, because of this process of competition being handicapped or handcuffed by collusive behavior, a lot of books have come out in the last just 10 years talking about how competition is being challenged and it's being stifled and it's being curtailed to the detriment of consumers at a micro level and economies at a macro level. So competition has to be safeguarded. So we are now approaching why we have competition laws and regulations in place. So competition has to be safeguarded. It's not something that's going to happen automatically. And competition is affected not only by the private sector behavior, but also by public policies. Even the government can sometimes issue or promulgate some regulation, some legal framework, which then affects competition. And this is not endemic or common to Pakistan. It even happens in very developed economies, as this slide shows, where the French Prime Minister was exhorting companies in France to buy only French solar panels. So this is sort of and this is the government minister sending a nudge to the market as to why competition should not be allowed to take place. So this element of restricting competition is a global problem. And when we come, Darren Acemoglu, who wrote his famous book in 2012, Why Nations Fail, but in a more recent article, he said, free markets are not unregulated markets. So some element of regulation is necessary no matter what the level of development or the freeness of a market is. So here we have the need for a competition law. And why do most countries have competition law? It allows players to compete fairly. So competition law sets the rules of the game if you want to participate in the market economy. I'm sorry. And it talks, I skipped to the slide, but it says competition laws generally prohibit anti-competitive behavior. And I'm going to explain what are the elements of anti-competitive behavior. But coming to Pakistan's competition law, and one of the panelists today, we were talking about the constitution, and in the 73 constitution, Article 18 was very forward-looking at that time. So it says freedom of trade and every citizen shall have the right to enter upon any legal, lawful profession or occupation and conduct lawful trade and business. Fair enough. So here's the Constitution guaranteeing a market economy and the freedom to participate in that economy. And it also says that trade or profession shall be regulated, and the regulation of trade, commerce, industry in the interest of free competition. So again, even before we had a competition framework, the framers of the 73 constitution were, like I said, very forward looking, and they put in this safeguard into Article 18. And it said that even if the government is involved in some trade, that should not be to the exclusion, complete or partial of other persons. So even if the government is participating in the market, it should not happen at the expense of consumers who also want to take part in that market. So here are some elements of competition. So the Competition Ordinance of 2007 established the Competition Commission, and this replaced our predecessor organization known as the Monopoly Control Authority. So the commission is a quasi-judicial. It has the process of conducting hearings. It is a regulatory body which looks at mergers and exemptions, and it is a law enforcing agency. It has the ability to impose penalties on egregious conduct. The commission works for promoting competition in the economy and economic activity, and it works to prevent or eliminate anti-competitive practices. So the commission comprises of 5 to 7 members, but unlike the previous law, which the members were entirely from government, this one has a safeguard that not more than 2 can be from the government. And the basic principles of Pakistan's competition law, well, it looks at abuse of dominant position. When you have a single 1 or 2 entities with significant market presence. It looks at prohibited agreements, when companies get together to collude. It looks at approvals of mergers and acquisitions as to how companies merge or work together under joint ventures, or when one company buys up another, etc. Competition advocacy, it is mandated in our law that we have sessions to help develop the market. And our element of consumer protection gives us the power to look at deceptive marketing practices. And we'll just quickly go through these 4 pillars very quickly. We'll start with prohibited agreements, because the larger quantum of cases that the commission has dealt with deals with cartel-like behavior. So what are prohibited agreements? So it's any agreement that has the ability or the effect or the object of restricting competition. So as Adam Smith said, a conspiracy against the public, or as Joseph Stiglitz said, firms inevitably seek to restrict it. This is how it happens, through some sort of an agreement. And agreements could either be horizontal, companies at the same level of the supply or marketing chain, or they could be vertical, up and down the supply or manufacturing chain. So prohibited agreements are also more commonly known as cartels. And you saw that in the video, that one of the challenges of economic activity is dealing with cartels, or being the economy being affected by cartels. So what is a cartel? It's an agreement between firms who should actually be competing but decide not to do so. And they get together and they formulate an agreement as to how to eliminate this competition. So now cartels are harmful because they generally have an impact on prices. And when you have a price impact, that affects you and I as consumers in our wallets. So you end up probably paying a larger surplus or larger quantum of money than actually you would in a very competitive economy. And internationally, cartels are subject to very high fines and in some jurisdictions, even criminal sanctions. People can be put into jail. Pakistan has a more administrative regime, so the Competition Commission can only impose financial penalties. And common types of cartel behavior, well, these four elements are what how cartels decide to maneuver in the economy. So there's price fixing. So companies who should be competing decide to set the prices or mirror each other's prices. Limiting or controlling output. Anytime you affect the quantum of supply and demand in the economy, prices, it has a direct impact on prices. Market sharing. How do you allocate markets? And if companies are involved in procurement for government projects, then they could be they could get together to rig bids. So we'll just quickly go through some of these. Market sharing is when geographical areas or customers are allocated between companies. So I may sell my product in Islamabad, but I'll ask my competitor not to come to Islamabad, and I will decide not to go to Lahore. So I've allocated the market. Or I may only work with government clients and he will only work with private sector clients. So now I've divided the market between geographical divisions or even by product divisions. So when you have these limits on what's happening in the market, you can actually isolate regional markets, or even you can isolate countries nationally. That's price fixing. I think not very complicated here. If I'm selling this clicker for 100 rupees, then I'll ask all my competitors, let's raise the price to 300. So we'll have easy profit. And now because we've fixed the price, no matter where you go to buy this clicker, you'll all be paying the same price. So here's an example of how prices are fixed. So it maintains, when you limit or control output, you're creating market conditions which limit the amount of supply available in the market. And the minute you have a shortage of some product, what happens to the price? It tends to jump. So this is how cartels agree on fixing the price or limiting what quantity of goods and services come into the market. If companies are involved in bidding for government projects, then what happens is that they set an agreement on who will win the bid. So every time you pick up the Sunday paper and there's government issuing tenders or floating bids for construction, services, etc. And there are some companies who decide that, let's rotate the bid or let's have an agreement on the prices, etc. And what is it that we'll quote to the government? So that eliminates competition. So that eliminates a very competitive environment from taking place for government procurement. And bid rigging, that's one aspect of bid rigging, the causes, but the regulatory framework also might be at fault here, because when you have increased transparency and you indicate the price for a certain thing, then prices tend to localize around that particular quoted price. So common forms of bid rigging could be cover bidding, etc. Competitors agree to submit bids that are way astronomically higher or quality wise that they're eliminated from consideration, making sure that the chosen one gets to win the bid. Or there could be bid suppression. People decide not to participate in favor of letting one of their friends or their colluding partners win that particular bid. Or there could be bid rotation. So I win the bid this time, and my cartel partners, we rotate the bids amongst ourselves. So we get an equal share of the pie, which keeps us in the market. Or there could be market allocation, something which I said before. I may bid for government projects, and my partners may bid for private sector projects, etc. So this is how the market is rigged, or bids are rigged when you're participating in procurement. In our experience, and this is not just our experience, but generally globally, there are certain industries that are very, very prone to cartelization. And the common factors that you see there is a smaller number of firms. Because if I'm to make a cartel with all of you in this room, it'll be virtually impossible for me to coordinate with all of you. But if I have like 3 or 4 people, then it's a very simple discussion, coordination, and we can sort of keep it under wraps and sort of agree on how the cartel will take shape. Homogeneous products. So if it's very difficult to distinguish products by branding, for example, sugar, you're not, when you go to buy sugar, you're not very particular that आपको एक ही brand चाहिए या एक ही company की चीज चाहिए. The same thing with cement, the same thing with wheat, the same thing with poultry. If you're not brand sensitive, then those industries tend to lean towards collusive behavior. Industries with similar cost structures tend to cartelize because price can be a major decision point for consumers who are looking to buy that thing. So anything that's, for example, if everybody's selling this clicker for 100 rupees, then people might get together and say that let's raise the price. So anything with a similar cost structure. No close substitutes. So there's no close substitute to, let's say, wheat, sugar, cement. So these industries are more prone to collusive behavior. And anytime there's availability of information on sales, capacity, pricing, etc., then that facilitates a cartel, because anything to do with capacity gives an indication that future may kitni quantum or kitni supply of a particular commodity or a product or service will be available in the market. So then people can plan accordingly. And if you're in the bidding process for government projects, etc., then that has a certain other dynamic of how collusion takes place. Some examples from Pakistan: poultry. Because of its homogeneous nature of poultry, the CCP has been active against the poultry sector, but not just in Pakistan. You know, this is an example from America a couple of years back, that even in America, the 65 billion poultry industry was victim of a price fixing cartel. And this is America. And America has a very strong legal framework, and America is pretty much the first country which launched the competition law framework back in the 1890s. So imagine, because of the homogeneous nature of poultry, even in America, the industry saw collusive behavior. 2020, in the middle of a COVID epidemic, generic 26 drug makers of generic drugs were accused of price fixing. So right in the middle of a very severe epidemic, which cost a lot of American lives, you know, so the industry decided, as Adam Smith said, you know, it becomes a conspiracy against the public. So people take advantage of market dynamics or epidemics, pandemics, to even, you know, profit from that. So that's human nature. And if you look at some of the names, Novartis, etc., these are pretty globally well-known brand names. So no industry, no sector, no company finds it hard to resist this thing of colluding. Example from Pakistan from a couple of years back with 2020. The power sector, we just had a power outage about 5 minutes ago. The power sector has been a perennial problem for Pakistan. And anytime the distribution companies have gone for procurement, they've been victims of bids that are rigged. So here's an example of what the commission did back in 2020. So 47 suppliers, 47 companies decided to rig bids for providing discos, distribution companies, line hardware, essential transmission mechanisms for getting electricity from generation sources to your house. What was the price here? Almost 5 billion rupees. So here we go. You know, this is how market dynamics, this is how competition is affected. What underpins a cartel or collusive behavior is the sharing of information. So we have these 4 elements, but what creates or facilitates a cartel is when companies get together to share information here. Now, some information is worth sharing because it helps develop the industry, it helps develop the sector, and people tend to work and get together to sort of for the betterment of what services or products they provide to the economy. But when it transcends into sensitive business information, for example, dealing with prices, rebates, discounts, etc., or even production distribution costs, forecast capacity, investment plans, anything that affects the future supply and demand of a certain product, which will have implications on price, that information should not be shared, because that tends to lead to coordinated behavior between companies who should actually be competing. Now, in Pakistan, in most laws, including Pakistan, there are certain agreements that may seem on the face of it to be anti-competitive, but the companies can apply to the commission, and they have, if they make a case that this agreement, it's seemingly anti-competitive, but it has technological efficiency or even social benefits to the economy, the commission and these benefits could not be provided without some sort of an agreement taking place. The commission receives an application, evaluates it, and then grants the applicants an exemption for a certain time period, 3, maximum 5 years, to go ahead with this agreement. But at the end of that period, they have to actually come back and justify that these were the reasons that we came to you for an exemption, and therefore this is what we have achieved. So and if they want to go for a renewal, so the commission, this is the exemptions are the commission's gateway clause to what are anti-competitive agreements here. So we'll continue with dominance and its abuse. We'll take questions at the end. I'm sure there are some percolating in your mind, but I'll just quickly go through my slides and then we can sort of discuss anything here. So dominance is when one or two companies have a significant share of the market. And one or two enterprises with a significant market power that they can work independently. They're not affected by competitive pressure from any other company. So basically, a dominant position denotes a lack of rivalry in the market. And this competitive pressure prevents these companies from sort of adjusting their prices downward or acting more competitively. Generally, being a dominant entity is not wrong, because we do want our superstar companies to grow. But when it comes to a point where dominance is being abused, that is problematic under the prism of competition law. And what happens is, our law defines abuse of dominance as behavior, any behavior which could be sort of affecting the market in certain parameters. Now, what exactly is that? There are two broad types of abuse that can happen. So it's either exploitative. A company could exploit its customers, or it's exclusionary. It could prevent other companies from entering that market and participating in there. So two broad areas of abuse. And if you look at what happens, how dominance can be abused, well, unfair purchase or selling prices or unfair trading conditions. So if I'm selling this clicker to all of you and I'm the only company, then I may impose certain conditions which are unfair to all of you and make it difficult for you to do business. But because I'm the dominant player, you have no choice. You have to come and deal with me. Limiting or controlling supply. Again, the minute supply goes down, prices tend to go up. Refusal to supply. So I may not work with this half of the room, but I'd rather work with that half of the room. I have no objective reason for doing so. It's my capricious nature or my whim or my fancy that I'd rather not deal with this side. So again, that's me abusing my dominant position. A discriminatory pricing. I may sell this clicker for 100 rupees to that side, but 500 rupees to this side. It's the same product. There's no reason for any price discrimination, but it's probably serves some perverse incentive for me to exploit certain customers or certain markets for this product that I'm selling. Applying different terms, different conditions to similar transactions. For example, I may have my accounts receivable come in 6 months for this side of the room, but maybe 1 week for that side, making it very difficult for them to sort of settle financial terms with me. So this is how dominance can be abused. And today, because we're very globally, the tech sector is driving dominance. So you notice you have a few companies that are very active technologically, and they tend to, because by virtue of network effects, consumer lock-in, etc., they are now being evaluated under the prism of dominance. For example, Apple is accused of locking people into its Apple ecosystem. Certain other aspects of how dominance can be abused, exclusivity, not letting my buyer or customer talk to other companies because I've tied them in. Or long-term agreements can sort of keep you as captive to me, and rather than letting you explore other comparative options in the market. Tying is making the sale of one product, conditional to another product. So if I'm selling you this clicker, I may decide to sell you the leather case for it also. You may not want it, but I'm imposing that condition on you. And because I'm dominant, you have nobody else to go to but come to me. And loyalty discounts. Now you think discounts would actually be a good thing because they tend to have a downward impact on prices. But if I'm selling something cheap and I keep you tied to me, it also prevents you from exploring much more competitive options because you think you're getting a good deal, but I may not be a very innovative company compared to somebody else who's offering a much better product or service. So this is how even loyalty discounts, seemingly beneficial, can actually be detrimental to the process of competition. So discriminatory business terms, predatory pricing, an economic concept, pricing my product below the cost, below the amount it costs me to make it in the effort to drive my rivals out of business in case somebody does come up. And once I've done that, if I have a significant market power, then I can raise my price and recover the money I lost during the period I was engaging in predatory pricing or any other form of restrictive clauses. So there are ways that dominance can be manipulated and abused by companies who have a significant market power. Who's this gentleman? This is Elon Musk. So now the manufacturer of Tesla, the electric vehicles. But more important is Elon Musk is the owner of Twitter in the last 2 years, I believe. But the yellow dots are the satellites that provide his Starlink services. So the figure from last year said that 53% of satellites in orbit around Earth belong to this one gentleman. So not only does he control a major platform by which information is globally spread, he's also controlling the means by which that information is provided. So he's up and down the supply chain, and that's causing a dominant position. So now the regulators are realizing that the tech sector is now leading or pushing towards possible abuse of dominance. So here's one example of this. NVIDIA is this month was declared the most highly valued company, $3.01 trillion. But when you're that big, they've been accused of abusing their dominant position. So the French competition regulator raided their office to find evidence of wrongdoing here. So the tech sector is now lending itself towards abuse of dominance here. Similar thing with Apple. It says Apple restricted third-party access to key technology to allow rivals to provide financial services in the Apple ecosystem. So they're excluding. So that was what I said, exploitative, but this is exclusionary abuse of dominance. So like I said, the tech sector is now leading towards possible abuse of dominance here. And a story from today, actually. So the American regulators are readying antitrust investigations into artificial intelligence. So these are common terms that we're listening to these days, but now there's possible collusive and coordinated behavior or abuse of dominance happening here. So the companies, OpenAI, everybody knows. Microsoft, everybody knows Microsoft. And NVIDIA, we just talked about NVIDIA. So these are companies that are growing large and sort of taking advantage of their dominant position, but they're causing concerns for the regulatory framework globally. Mergers and acquisitions are when, I just came across this figure that in 2022, just the gaming industry saw mergers and acquisition activity to the amount of $51 billion. Now that's a pretty large quantum of funds. So, and the year before, they said the figure was $74.5 billion of mergers and acquisition happening in just the gaming industry. Now, how many of you play games? My son plays PlayStation, so I'm constantly watching him play these games, but I never realized that there's so much money involved in the industry, in the production and development of video games. So reasons for mergers today, in the 80s and 90s, when companies had a lot of money, they stepped out of their national borders and they went and acquired companies in Far East or Europe, etc. So it allowed them to gain a foothold into new economies or new markets and new territories. But today, mergers are happening because of big data. Actually, the concept of big data is, there's so much available in different companies and other companies want to take advantage of it. Research and development, always, because you're trying to have this process of innovation, and if somebody else has put in the money and the effort, you might as well pick up that company rather than recreate that effort to do R&D, or even intellectual property. So gaming industry is, you see a lot of M&A in gaming industry because of the intellectual property there, and the research and development, and the big data. So here's one example of not an acquisition, not a merger, but maybe a joint venture, which is also covered under the competition law. That when Apple launched its banking product in partnership with Goldman Sachs, it took them 4 days to get $1 billion worth of deposits. 4 days. Because Apple is sitting on a mountain of customer data, which they could sort of evaluate, analyze, and then convert into usable data, and they captured a pretty substantial chunk in 4 days. Can you imagine one financial product by a company that is not even a financial sector company, more of a tech company, is now sort of transcending or crossing over into the financial services sector. So this is how data is driving a new wave of M&A activity globally. But when you have mergers and acquisitions, one of the reasons, this is the McKinsey article from 2022, which says, although mergers happen and are encouraged or generally tend to take place, one of the reasons that they fail is because of the regulatory antitrust frameworks globally. So many mergers and acquisitions do not clear the hurdle of regulatory approvals here. So in Pakistan, this is our section 11, and says that the commission will review, because we have a mandatory merger regime, any 2 parties or 3 parties that are deciding to merge or work together or in a joint venture or go for an acquisition, they have to report this transaction to the commission for clearance. And the commission looks at it because if you have M&A activity happening, is it creating a dominant position because you're reducing the number of competitors in the market? Or will it facilitate establishment of a cartel? Again, it's easier to put together a cartel when you have 3 or 4 players rather than 15 or 20. The most problematic ones are horizontal mergers because they tend to directly eliminate an effective competitor. Here. So what happens, the anti-competitive effects is that the joint company can resort to unilateral behavior, raise prices, diminish quality of services or products, etc. Or it reduces the number of players where they can tend to coordinate more effectively and easily. There are 3 different types of mergers. So it's a vertical merger, up and down the supply chain. So you go backwards or forwards and you capture the supply chain. Or you can have horizontal mergers. For example, in this example, 2 grocery stores tend to get together. And the third one is a conglomerate merger. 2 companies in completely unrelated fields get to join forces here. The commission looks at merger thresholds from the size of party and the size of transaction analysis. And this is very specific, but I thought I'd just add this in here because there are certain financial values by which mergers and acquisition applications are evaluated by the commission. And here are some examples of, this is an example of a conglomerate merger. So when Amazon decided to pick up MGM Studios, the rationale behind it was to get the catalog of the entire James Bond movies, because Amazon also is a rival to Netflix through Amazon Prime. So they wanted to have the catalog of movies that they could stream. So here's an example of a conglomerate merger. Amazon itself is more of an e-commerce vendor than it is more of a streaming service. But this is it transcending or sort of crossing over into a different market. Some examples from Pakistan, an LNG terminal case came to us last year, and Coca-Cola Turkey was investing in Coca-Cola Pakistan. And in January 2020, Uber Careem's merger took place. And this was, again, an example of a data-driven merger because Careem had been established in Pakistan, had a lot of customer data. Uber did not want to start from scratch, so they decided to pick up Careem. And Mobilink Warid, when Warid was exiting the market in 2015-16, and Jazz picked it up. So this merger was also reviewed by the commission. One recent case of a merger, again in the gaming industry, where the UK's competition regulator was concerned that Microsoft picking up Activision could actually hurt other gaming companies like Sony and PlayStation. So they imposed a lot of conditions before, reluctantly, they gave the go-ahead for this merger activity to take place. Some element of consumer protection that we have in our law is deceptive marketing practices. But before I get into that, competition law looks at distortions on the supply side. How do companies work in the economy and get their products and goods and services to the market? So is there any price fixing there? Is there any collusive behavior? Is there anything happening as to how products and services are brought or sent to the market economy? The consumer protection law looks at distortions on the demand side. So if I'm going to the market, how do I make my decision as to how do I decide between product A and product B? And what is this aspect of deceptive marketing that can influence, maybe positively, maybe negatively, my purchasing decision? So let's look at what happens here. So there's certain critical aspects of advertising that need to be considered by people who are actually very active in selling in the market. Advertisement should be truthful, should not exaggerate the usefulness or quality of the product, and should not play on the emotional needs of consumers. And let's just talk about some of these things. So false and misleading information. False, not true. Misleading, it gives a completely different idea than what is intended to be. And when we look at deceptive marketing, the spread of false and misleading information, the powers given to us by our law, these are the four aspects by which the commission evaluates any deceptive marketing case. Is it capable of harming another business? What does it tell you about the price, place, product, suitability, or characteristics of whatever that is being sold to you? Is there any comparison of goods which is misleading or inaccurate? And is there any trademark or copyright infringement of another company's intellectual property here? Some examples that the commission has actually dealt with, and these are quotes from actual cases that the commission has intervened in. So the distribution of false or misleading information that can harm the business interest of somebody else. So 100% pure, generally to do with juice, but I think we know that there's no such thing as nothing can be 100% pure. 99.9% of germs, very difficult to prove that. So you're really at the beck and mercy of the marketeers here. Number one in Pakistan, again, who makes this determination? Who evaluates this? Top rank and accredited. This is mostly to do with academic institutions. Scientifically proven, yes, but by who? Who's the body of the science body that proved this? Free from additives, again, very, very impossible to have something that's entirely free from additives. So these are deceptive marketing claims that the commission has looked at that are capable of harming another business here. False or misleading information to consumers regarding lacking a reasonable basis on the price, place, etc. So pure juice, miracle cure, weight loss products. Again, what I talked about, tapping into the emotional needs of consumers. Lose 10 kgs in 10 days. These claims are far too exaggerated, but they tend to sort of prey upon sort of an emotional need, and then they tend to encourage a transaction which is not, and what you get in return for that transaction is not what you expect, because it doesn't really happen. Dairy whiteners were being marketed as milk, whereas they're entirely chemical products, etc. And universities' suitability, quality, employability of students, etc. So there are a lot of egregious claims tend to be made in marketing campaigns. False and misleading comparison, again, lasts twice as long, twice as effective, kills twice as many germs, etc., etc. But then again, there's no scientific basis for these claims. And more commonly, a fraudulent use of somebody else's trademark or brand name. Companies spend a lot of money, effort. They put in, considerable effort into developing a brand identity. So you notice, National Foods is a very old company, established in 1970. So for the last 54 years, it's been working in Pakistan. It has a certain brand identity. But then what happens, we notice, and not just with National Foods, other companies also, other newcomers tend to exploit or tend to take advantage of somebody else's branding or packaging or intellectual property to try to fraudulently sort of pass themselves off as similar products. So these are issues that we have seen in Pakistan. So our consumer protection aims are to encourage the disclosure of sufficient information. So when you go out to the market, you're actually what we call an empowered consumer, and your decisions are based on information which is accurate and not bought for or paid for or financed by vested interests or sort of some sort of profit motive here. So the commission also provides solutions and guidelines to undertakings to help modify the thing. And for this reason, we work very closely with the Pakistan Advertisers Society, whose representative, Ms. Afshin Rizavi, is here with us. And the commission also provides a platform to help sort of address these grievances when it comes to deceptive marketing here. I'll now come to practical guidance for competition law vis-a-vis the accountant's profession. So what is competition law and why might, and now this is a question you'll probably ask yourself, why should what kind of advice or what kind of help can I give my clients? Okay. So competition law ensures, that businesses compete fairly, etc. But there's also a significant lack of knowledge amongst businesses on the implications of competition law. Breaking the law can incur significant penalties, and businesses can be fined up to 10% of their turnover. And this is the same in our law. This is generally a global figure. Both small and large businesses are at the risk of CCP's enforcement action. And there's a certain reputational harm which comes from, if the CCP takes enforcement action against you, might not be good for optics. And just to give an example of, these are the penalties from 2007 to August 2023. And if you look at the chart, forget about the quantum of penalties for the moment. But if you look at the sectors where the CCP has intervened, there's pretty much no sector where the commission has not found some violation of competition law. I mean, there's aviation, courier services, pharmaceutical, sugar, again, the homogeneous product, telecom, agriculture, cement, another homogeneous product. There is no sector of the economy where the commission has not intervened and taken enforcement action. So what does that tell you about the nature of competitiveness of Pakistan's economy? I'll leave that up to you. Accountants generally help business and their owners protect profits and assets, and making companies understand what competition law is and the associated risks is one way of you as professional experts helping your companies make sure that there's no violation of the law. So some questions you may wish to consider: do your clients really know what anti-competitive behavior is? And what is the level of sort of or the desire to ensure compliance with the law? What are the potential penalties for breaking competition law? And so now this is under the pillar of competition advocacy. This is now creating awareness of the law and what are the implications. And you as accountants or as a professional body, this is knowledge that you need to sort of pass on to your clients here. Do companies have systems in place to deal with competition law risks? Now, do they have compliance programs? Larger companies tend to do. Smaller companies may not have the resources, but they may actually need to consider how they can sort of bulletproof themselves against competition law violations here. Help clients understand. This is something that accountants do. I don't think it should only be about numbers and financial statements, etc., but it's more to understand risks and assets, as I said in the previous slide. One of the documents that will be helpful to you in the discharge of your professional duty is the Commission's guidance on competition compliance, and this is available on our website. And if there is a fear of some anti-competitive behavior that has taken place, maybe you can encourage them to seek legal advice. Given that the Commission has been working for the last 17 years, even the legal fraternity is aware of what it means to be compliant with competition law. And the CCP also has a leniency program in which cartel members or a cartel member can actually come forward in full confidence and divulge details about the cartel and help. This is a news story from 2020 where a cartel member who was involved in a price fixing conspiracy came forward and shared information with the CCP. So when companies who tend to do that may benefit from having their financial penalty reduced or completely waived. So there are benefits of divulging cartel information to the commission. So some questions that you need to ask or help your companies that you work with understand, when you're talking about prohibited agreements, cartel agreements, is there any written or oral agreement which is designed to limit or eliminate competition amongst the people in the sector? For example, do you share same suppliers as your competitors? Because that might tend to send a price signaling mechanism which facilitates a cartel. Are your customer suppliers also your competitors? So that's a very complicated web of relationships. So you're competing with them, but you're also in that buy-sell arrangement. So that might also give you an example of, if I'm buying this clicker for 100 rupees, then his price in the market must be around 195 to 105 rupees. So that, because of that purchase agreement, I can sort of predict my competitors, who's also my supplier, his pricing formula. Do you ever work in partnership with your competitors? Associations tend to do that, to work together, but it might cross a line which going from benign collaboration, it becomes a more sort of a conduct which is then possible violation of the legal framework. Or is there any geographical or consumer-based market allocation amongst yourselves or the companies in the same sector or industry? Employees. Is there a heavy turnover or rotation of employees between your competitors? So they may have privileged information that they may take over to the next employer, and that may facilitate signals or pricing or capacity or forecast decisions or investment plans, etc. What about exchanging views with competitors about costs and prices? That's sensitive, confidential business information which should not be shared under any circumstances. But inadvertently, in the sake of conversation, we tend to divulge more than we think we have, because we are friends with people, we meet them frequently, we see them everywhere. Our children may go to the same school, etc. So there are the aspects of communication which happen more in a brotherly nature than more under the guise of a business discussion. But some of that could be sort of wrong. So do employees seem to have information about competitors' prices or business plans that result in the marketplace? So again, this, like I said, cartels are underpinned by the sharing of information, and some of this is what constitutes a red flag that facilitates a cartel. In rigging bids, talking about competitors about how to participate in a particular bid. Is there rotation, or is there cover suppression, or is there not participating in a bid in the hope of letting somebody else win that bid, and then the next time around that party returns the favor to me and lets me win that bid? Or is there some sort of a tender that was submitted that is hugely very different from a normal tender response to a certain bid that's floated? Price may be astronomically high. I'll give you an example. We talked about line hardware. In 2009, Pesco issued a bid for 3,000 meters. These are meters which are placed outside houses which monitor electricity usage. So they wanted to purchase 3,000 meters, and 3 companies got together to prepare a response to the bid. And each of them said that we'll quote 900 meters for 3,000 rupees each. So not one company was not fulfilling the entire order. So between setting the quantity and the price identical to each other, all 3 companies got a share of the bid. So this was collusive behavior. And this is a 2009 case. When you go to our website, you'll find this inquiry report and the commission's order there. Abuse of dominance, pricing. If you're dominant, how does your pricing play out in the market? Is it like way too high? Way too high, meaning the commission is not a price fixer. Commission does not encourage price fixing by entities. Neither does it engage in price fixing itself. But there are certain elements of price which even seem like an outlier to you. It could be really high or really low. So both are problematic here. What about different price and sales conditions? Are there any objective reasons for having discriminatory price sales conditions? Are there any obligations that are being imposed on customers? Or what about restrictions, that I may sell my product and tie it with a lot of restrictions, dictating what you can and cannot do with what I sell to you? So these are indicative of possible abuse of dominance and have to be looked at very, very carefully. What about determining the resale price for dealers and different consumers? If I sell a product to you, it should be your full discretion, your full liberty to see how well you can move that product out to your groups of customers and consumers. And I should not really have a say in that, because you have to look at the market, you have to understand the competitive dynamics you're facing, and then you have to respond appropriately. But rather than me dictating the price, that means if I'm in a position to dictate that price, that means I'm in a dominant position and I'm possibly abusing it. Just to summarize and conclude, a very good book which came out a few years ago, and more on behavioral economics and how or individuals or companies can be sort of nudged or steered into taking certain decisions. But one of the points that I remember from this book, and the author said that if you want to encourage people to do something, you have to make it easy for them. And one of the reasons behind presentations like these is, we're trying to make the understanding competition law easy. So let me just quickly summarize. So cartels generally engage in price fixing, supply fixing, or market allocation. What happens is it eliminates competition. So abuse of domination, dominant position is like extracting, charging a way higher price and extracting extra profits, or excluding potential competitors from coming into the market. Anti-competitive vertical agreements, etc., impose their agreements. So they're cartel-like things, but they could be abuse of dominance also, because I may be setting the price for how my dealers operate in the market, etc. And it can form an entry barrier. It can sort of limit how the market mechanism operates freely and unhindered, and allows prices to stabilize at what the market can really afford here. Anti-competitive mergers can create a monopoly or a dominant position, or facilitate the formation of a cartel by reducing the number of players in the economy here. Again, coming back, to understand, we put together our document in 2016 called the Guidance on Competition Compliance. It explains all aspects in a very simple, jargon-free manner, no legalese, no law, but just simple concepts, or the law explained very simply. But apart from that, the International Chamber of Commerce has a very good antitrust toolkit, which covers a lot of things that, you as professionals, in terms of compliance, risk identification, assessment, whistleblowing, handling systems, etc. There's a lot of information in the ICC's antitrust toolkit, which may be useful to you as you embark, or as you continue on your professional development journey to provide value and services to your customers. And that was it. That was my presentation. I hope the aspects of the law, the regulatory web, as Vesab said, I hope that it's not as complicated as it may appear to be, and that we managed to explain it to you relatively simply. So thank you so much for your time and your patience.
Thank you so much, Mr. Ahmed Kadir, for sharing an insightful presentation with us. So now it's time for the moment we all have been waiting for. It's time for an insightful panel discussion. And we have gathered a panel of experts whose knowledge and wisdom will surely enlighten and inspire us all. So our first panelist is Ms. Rida Aslam Bhatti. She is a corporate lawyer by profession, having completed her LLB from the University of London and her LLM from BPP Law School in Manchester. She is currently serves as an associate partner at Ria Barker Gillette, Pakistan. So please welcome Ms. Rida Aslam Bhatti. So our second panelist is Ms. Afshin Rizavi, who brings her over 2 decades of invaluable experience in the advertising business. She has been serving as general manager of Pakistan's Advertisers Society for the past 7 years. So please join me in welcoming Ms. Afshin Rizvi. Our third panelist is Mr. Khwaja Atif, who brings over 4 decades of invaluable experience, and he has served as the secretary of Pakistan Petroleum Association from over 2 decades and continues to serving. So please welcome Mr. Khwaja Atif. So our next panelist is Mr. Nosherwan Khwaja. He is an associate chartered accountant and he is the partner of Iqbal Yasser and chartered accountants, and he's also a renowned teacher in the Sierra fraternity. So please welcome Mr. Nosherwan Khwaja. So now, to guide us through this session, we are honored to have with us the chairperson of CPD Technical and Professional Affairs Committee by NRC. She is a seasoned finance professional with over 2 decades of invaluable experience. For almost a decade, while working with PECRA, she has closely studied competition and its impact on wide range of industries of Pakistan. So please join me extending Ms. Amara Gundal. She's already on the stage. So with this, I hand over the stage to Ms. Amara Gondal for the panel discussion. So over to you, Ms. Amara Gondal.
Thank you so very much, Awais. Assalamu alaikum, everyone. And thank you so very much, our prestigious panelists. And we are lucky to have such a diversified panel, which normally we don't have such diversified panel on the stage. Normally, it's occupied by all members and seniors of the fraternity. And definitely, this is because the competition laws, when we talk about competition and laws and its implementation or enforcement, then we have to look at different angles. So that was the reason that we invited, such a diversified, and definitely इसमें बहुत ज़्यादा input है सलमान साहब का in arranging and deciding all on the panel. Just a brief introduction ke how we are going to take this panel discussion, and accordingly, because we have a law expert with us, and we have the dealer or the association, we have an advisor advertisement society with us, and definitely जब तक हमारे अपने member हमारे stage पे नहीं होंगे तो वो justify नहीं कर सकेंगे, since that is going to draw relevance to whatever we are talking about today. So I would start off my panel first question, and before I proceed, our online participants, all of you can put up your questions. First, a round of question answers would be happening here, and then the floor will be open for the question and answers. My first question goes to you, Ms. Rida, since you are associated with law and enforcement, and you have closely studied that the competition laws we would talk about. What role do they play in the developed countries from which we can draw a relevance for the developing countries like us? On.
Right. So I think the principles of competition law across the board in developed jurisdictions and in the developing world are pretty much similar. And, the laws in the developing countries are also inspired from the developed jurisdictions. So what was already presented today, it's primarily the same, that in developed economies, it is a primary concern that the markets are competitive. And why should the markets be competitive? It is to ensure, amongst other things, that there is economic efficiency, which translates into better quality and provision, better quality of the services and the goods that are provided to the market. There is a level playing field. The prices are competitive. There are minimum barriers to entry. There is no abuse by the dominant market players, and they cannot distort the competition in the market. And there is no deceptive marketing that was already elaborated upon. Now, there are various tools that the regulators across the world employ to ensure that these basic principles are essentially ensured. And I think that the law across the world, it may be phrased in a different manner, but primarily it is basically these principles that competition law seeks to safeguard. So just drawing inspiration from, because look, I would say this, that, the law that competition law that we have in Pakistan, it is a state of the art law. So it does cover most of the principles and the concepts that are required to be, present in the law in order to, to ensure that there is competition in the market. But I'll just give you an example from another, developed jurisdictions, which is the EU law, which also, a lot of countries seek inspiration from, and even us, when we are looking at certain, competition related cases, we do our research in these other jurisdictions to see how they have interpreted competitive practices or anti-competitive practices, and also to kind of seek or plug the gaps in the interpretation of the relevant laws, or, for room for improvement as our jurisprudence also develops in Pakistan. So in the EU as well, primarily there are 4 areas that the law seeks to protect. A, it's cartelization and collusion, which is basically abuse of dominant position. B, mergers. So the point or the idea behind regulating mergers is that it should not create any dominant position in the market, which then leads to abuse. So that's why, mergers are evaluated across the world to assess that no merger is taking place in the market which has the, direct or indirect impact of distorting competition. Although now with big tech and digital platforms, this is becoming increasingly difficult to ascertain. And I think this is something we'll touch upon later in our discussion as well. And it has already been touched upon in the presentation. So yes, market dominance, cartelization, mergers. Interestingly, there is another area that the EU regulates, which is not regulated in our jurisdiction. It is the provision of state aid. So the EU also, whenever there is aid that is provided by the government to any industry or to any corporation, that also falls within the purview of competition law, and there is an approval that has to be sought from the relevant competition regulatory authorities, for the reason that it might create distortion in the market. Because if state aid is provided to any specific sector, industry, or, any corporation. So for example, renewable energy or development of, chips, etc. These are just, IT chips. These are just few examples. That is creating a favorable position for that particular, corporation or that sector. And it might also lead to an imposition of some kind of direct or indirect levy on the consumers. So the EU takes that very seriously. They say, you come to us, we have to assess whether this is, there are certain, they have kept certain criteria by which they assess that whether, it is promoting social growth, economic growth, whether there is any policy agenda related to it. And overall, that, balancing act that every competition regulator sort of seeks to perform is that whether the benefits of that particular provision of aid or distorting of competition, if it is happening, whether it's the benefits of that outweigh any adverse implications on competition.
Okay. So you are saying that there are certain laws and regulations that are there, but that is not still in Pakistan. And definitely there are, certain, because the markets are not that mature.
Correct.
When we talk about, subsidy or the government aid, तो यहाँ पे तो बहुत से मसले मसाइल हमारे power के और ही नहीं हो रहे. But definitely there might be something that competition commission might be looking into, or laws में कुछ और further development might come. या fertilizer sector में अगर उसको subsidy मिल रही है तो how this is impacting. So we can talk about it in later questions. So now I would like to direct my next question, because initially जो question each panelist say I'm going to put up, that would be a kind of, introductory. Because after setting a tone at the economy, now we would like to understand from you, Afshin, that what is the role that Pakistan Advertisers Society, definitely you are representing that, and this is said that this is a self-regulatory society. So like, what is your responsibility? If you like to talk about a little bit of it, since, all the local and international brands are your members. So what are the responsibilities that you assume in terms of, coordination with the regulators like, CCP?
Assalamu alaikum, everyone. First, I think we're a society and we self-regulate. So self-regulation, I think it's very common. मेरे ख्याल से अगर मैं आप सबसे definition पूछूं, तो self-regulation is it's the ability to control your feelings and thoughts. So thoughts दो तरह के होते हैं, emotional होते हैं और behavioral होते हैं. इमोशनल थॉट्स पे किसी का कंट्रोल नहीं होता बिकॉज सबके अलग अलग ऑपरेट कर रहे होते हैं बट बिहेवियरल थॉट्स हमेशा कंट्रोल हो सकते हैं एंड दैट लीड्स टू सेल्फ रेगुलेशन मैं आप हर आई थिंक एवरीवन इन दिस रूम at certain point in time self-regulate करते हैं because we pray 5 times a day which means we self-regulate. Exams के time पे हमारे बच्चे पढ़ रहे होते हैं we self-regulate. So if we can self-regulate in our personal way of upbringing and related to the environment, why can't we self-regulate at workplace? That is what the core idea is. So I represent a society by the name of Pakistan Advertisers Society. हमारे पास 40 member companies हैं. And वैसे लगता बहुत छोटा सा है कि 40 member companies हैं, but it constitutes approximately 85% of the advertising spent of the country. Obviously हम society हमने क्यों बनाई? So 1996 में ये society form हुई थी. It is formed for advertisers to empower them. उनको empower करना था so they could self-regulate, and that is one of the core function or core pillar of the society. So the society works on 4 pillars. जिसमें एक होती है capability building, which is the resource building, यानी कि लोगों को train करना as professionals. So हम marketing और advertising हमारा core function है और उसी से relate करके it could be digital, it could be accounts also to some extent, to sales to some extent, but core function हमारा marketing and advertising है. So उससे relate करके anything which comes into that ambit हम capability building करते हैं. फिर हमारा एक core function है which is the advocacy and self-regulation. That is the foundation. इसके अलावा हमारे पास 2 हमारे और functions हैं. जिसके अंदर एक आता है सोसाइटी एंड सस्टेनेबिलिटी. तो हम वी डू अ लॉट ऑफ वर्क ऑन सस्टेनेबिलिटी, जैसे DEI हो गया, DEI हो गया, और इस तरह के इनिशिएटिव्स हम लेते रहते हैं. और ये हमारे 4 फंक्शंस हैं जिसपे हम प्राइमरीली सोसाइटी हमने खड़ी की है. तो जब सेल्फ रेगुलेशन आई तो हम अपने मेंबर कंपनीज को एम्पावर करते हैं कि सेल्फ रेगुलेट करो, रादर देन गोइंग टू दी competition commission, or rather than being जैसे कहते हैं कादिर साहब ने बताया कि imposed होंगी आप पे sanctions इस तरह की, you'll go through a process. तो हम बोलते हैं उससे पहले ही self regulate करें. So we personally have a lot of workshops, we have a lot of seminars entitling them कि किस तरह से आपने self regulate करना है. हम we believe in no misleading communications because हमारे लिए marketing communication main crux है. और वो communication जो आप TV पे देखें, radio पे देखें, outdoor पे देखें, digital mediums पे देखें, that is what our bread and butter is for our member company. तो self regulation को हम core लेके और उस पे हम बहुत सारे seminars करते हैं, उनको बताते हैं. We have a mechanism भी है हमारा, which we will talk about in later. अब बात आ गई कि हम CCP कहाँ से हमारे साथ, how do we come into?
We can say that before going to CCP, they have to go through you first.
No, so हम कहते हैं कि why do you want कि आप पे
Go to
कुछ
CCP.
impose हो, ठीक है?
Yeah.
So rather than that, you know, यहीं पे sort out हो जाए, यहीं पे चीजें इस तरह से हो जाए,
बहुत ज्यादा awareness activities you would
भी
be,
हम करते रहते हैं. But हमारे पास 40 member companies, although they constitute 85%, लेकिन still हम सिर्फ 40 लोगों, 40 member companies को देख सकते हैं. But CCP has got a larger ambit. So what we do is that we collaborate with them. We have these workshops. अभी भी हमारे पास एक seminar हुआ था last week, I think, in Karachi. And we had team CCP over there, and we had called all our member companies. और उनके लिए एक initial हमने वो किया. So we have these kind of collaborative workshops, seminars, ताकि हम उनको शुरू ही से, you know, we kind of train them to self-regulate.
more of awareness, and they should
Yes.
know what to comply and what not to comply.
Yeah.
Thank you so very much, Afshin. And now I would like to talk about the Association of Petroleum Dealers with you, Atif Saab, since you are representing it. आप थोड़ा सा एक introduction दें, how it is its composition, or talk about a little bit of this sector and its relevance or importance to the economy. फिर उसके बाद हम देखते हैं competition के बाद में फिर बाद में बात
Good.
करेंगे.
Okay, thank you very much. On behalf of my association, I thank Competition Commission of Pakistan and CA Pakistan for arranging such a nice seminar, which is at least much required for us as an industry. और उसके बाद हमारा जी all over Pakistan, we have 14,000 petrol stations, inclusive of all remote areas and northern areas. Or secondly, we are in the top 5 tax contributors of Pakistan. We are paying around 230 billion rupees a year to the exchequer. Secondly, our industry is serving 24/7 rather. And I mean, अगर घर में खुशी है तब भी, बारिश है तब भी, तूफान है तब भी, अगर कोई घर में गमी है तब भी. We are serving the people. Even during the youngsters also haven't seen the martial laws and curfews. तो उस वक्त भी हम लोग ऑपरेट करते हैं and we are functional.
And definitely we can vouch कि dealers अगर strike पे जाते हैं तो तब हमारा क्या हाल होता है.
Or being the top 5 contributors of tax, unfortunately, we are treated as a second-grade citizen from the government side sector and from the OMC sector as well. So this is the high time, and this is a very informative for me, this seminar. Especially, we don't know our rights and also don't know the limitations of government sectors or the OMCs. So it's very informative for us. And the punchline of Mr. Ahmed's lecture was the abuse of dominant position. We are the classical victims of that. So that I will discuss later on when the question and answer session will start.
Definitely. Thank you so very much. Naushawan, your turn. Definitely. The last panel hota hai, so everybody has to wait for their turn. Thank you, Naushawan, for joining us. आपका role is definitely कि हम सबसे पहले तो relevance draw कर लें कि competition laws की हमसे क्या relevance बनती है. Like we work as CFOs, finance professionals हैं, हम practice में भी हैं. Board members हैं, governance को भी देखते हैं. So how do you see that what is its relevance and how importance it has gained recently for the CA fraternity? How do you draw that relevance?
Thanks so much, Mara. First of all, we have to differentiate the CA's role. So basically जो CAs होते हैं sometimes they are working as consultants and sometimes they are in the management side like working as CEO, CFO and sometimes they are the board member as well. So we need to understand the role of each and every participant. In such cases we just work together for the betterment. तो उसमें जो कंसल्टेंट का रोल होता है वो एक गाइडिंग रोल होता है जिसमें कंसल्टेंट जो मैनेजमेंट को अच्छे तरीके से चीज़ों को एक्सप्लेन कर सकता है. सो इन दीज ऑल सिचुएशंस जहाँ पे कंपटीशन की बात आती है तो वी नीड टू अंडरस्टैंड कि इंपॉर्टेंस हमारे लिए उसकी क्यों जरूरी है. So there are basically three different dimensions on which we have to evaluate our decisions. First of all is the decision making process. Second is the risk management and third is the reputational risk which is also relevant to the risk management. तो जब डिसीजन मेकिंग की बात आती है तो वी नीड टू नो व्हाई द कंपनीज आर गोइंग टू मर्ज. क्योंकि हम कंसल्टेंट के रोल पे भी काम कर रहे होते हैं, हम मैनेजमेंट के रोल में भी काम कर रहे होते हैं, तो नीड असेसमेंट और ऑब्जेक्टिव ऑफ द मर्जर या एक्विजिशन को समझना बहुत जरूरी होता है. जैसे कि अहमद साहब ने बड़ी अच्छी तरीके से एक्सप्लेन किया था, वर्टिकल मर्जर्स होते हैं, हॉरिजॉन्टल मर्जर्स होते हैं. समटाइम मार्केट की जो कंसंट्रेशंस होती हैं उसको भी मर्जर हो जाते हैं, समटाइम प्रोडक्ट्स की भी मर्जर्स हो जाते हैं. लाइक अगर आप मार्केट की बात करें, आप एक मार्केट में काम कर रहे हैं, मैं दूसरी मार्केट में काम कर रहा हूँ, हम दोनों मिलकर एक जो है वो मर्ज कर लेते हैं. मर्जर इज समथिंग डिफरेंट फ्रॉम द एक्विजिशन. एक्विजिशन में सर्वाइविंग कंपनी जो अक्वायरर होता है सर्वाइव करता है. मर्जर के केस में जो दोनों कंपनी मर्ज होकर एक नई कंपनी बन जाते हैं. सो दिस इज द बेसिक फर्स्ट डिफरेंस बिटवीन द टू. अब डिसीजन मेकिंग प्रोसेस में वी यूजुअली हेल्प द मैनेजमेंट इन मेकिंग द डिसीजंस कि आपको मर्ज क्यों करना चाहिए. समटाइम ये नीड आपकी किसी और तरीके से भी फुलफिल हो सकती है. फॉर एग्जाम्पल कंपनी के पास अगर अच्छे रिसोर्सेज हैं, फंड्स हैं एंड दे कैन हैव द इंटरनल प्रोडक्ट एक्सटेंशन, तो उस केस में मर्जर की जरूरत नहीं होगी बल्कि वो प्रोडक्ट एक्सटेंशन के थ्रू अपने नीड को फुलफिलमेंट कर सकते हैं. समटाइम वी हैव द प्रेजेंस इन डिफरेंट मार्केट्स, तो उस केस में हमें मार्केट के लिए सेगमेंट जो मर्जर है या एक्विजिशन उसको करने की जरूरत नहीं होती बल्कि वी कैन गो इनटू द न्यू मार्केट विद आवर ओन रिसोर्सेज. इसी तरह से ये तो बेसिकली डिसीजन मेकिंग के प्रोसेस में बात आती है. तो यहाँ पे हम बीइंग चार्टर्ड अकाउंटेंट्स क्लाइंट को गाइड कर रहे होते हैं रिगार्डिंग डिसीजन मेकिंग प्रोसेस कि आपको इसमें क्या करना चाहिए और क्या नहीं करना चाहिए. सेकेंड एस्पेक्ट इज द रिस्क मैनेजमेंट. जाहिर बात है कंपटीशन कमीशन ऑफ पाकिस्तान एक हाईली रेगुलेटेड अदारा है जिसमें काफ़ी सर्विलेंस के पॉइंट ऑफ चीज़ें बहुत ज़्यादा क्लोजली मॉनिटर्ड की जा रही होती हैं. इवन विसल ब्लोइंग प्रोसीजर इनका बड़ा इफेक्टिव है, उसमें लोग बड़े बढ़ चढ़ के कुछ पार्टिसिपेशन करते हैं क्योंकि इसमें एक मॉनेटरी बेनिफिट भी होता है, समटाइम कुछ रिक्वायरमेंट्स भी होती हैं. तो इंफॉर्मेशन इज टू मच अवेलेबल विद देम. दूसरी बात क्या होती है कि समटाइम कंपनीज आर वेल नोन, उनकी इंफॉर्मेशन पब्लिकली बहुत अवेलेबल होती है. लाइक मल्टीनेशनल कंपनीज होती हैं, ज़्यादा उनकी रिक्वायरमेंट होती है इस तरह की प्रोडक्ट एक्सटेंशन के अंदर जाने की या इस तरह करने की. तो कंपटीशन कमीशन के जो लॉज एंड रेगुलेशंस हैं जिसमें बड़े स्पेसिफिक रूल्स एंड रेगुलेशन बेस्ड काफ़ी चीज़ें मौजूद हैं, तो उसकी अंडरस्टैंडिंग होना बहुत ज़रूरी है कि मर्जर की या एक्विजिशन के ऊपर हमारे ऊपर कंपटीशन कमीशन कब आएगा, आएगा तो किस तरीके से उसकी रिक्वायरमेंट फुलफिल होंगी, व्हाट आर द कोर्स ऑफ एक्शन दैट दे विल फॉलो. सो वन साइड इज with respect to the compliance and second side is with respect to the risk. तो compliance को किस तरह से इंश्योर करना है, फॉर दैट वी शुड हैव अ गुड अंडरस्टैंडिंग ऑफ द लॉज एंड रेगुलेशन. और रिस्क के पॉइंट ऑफ व्यू से वी शुड अंडरस्टैंड ईच एंड एवरी नॉन कंप्लायंसेस मैटर्स. अगर नॉन कंप्लायंसेस होंगी तो व्हाट विल बी द अल्टीमेट इम्पैक्ट ऑन द कंपनी, जिसमें आपको कंपनी की रेपुटेशन पे बहुत बड़ा क्वेश्चन मार्क हो जाता है. जिस तरह से उन्होंने बड़ी बात की कि अगर अखबार में एक न्यूज लग जाए और कंपनी इज लिस्टेड ऑन स्टॉक चेन तो यू विल सी अ ह्यूज मूवमेंट इन द स्टॉक प्राइस. तो वो एक बहुत बड़ा इम्पैक्ट क्रिएट करती है. सिमिलरली जो ट्रस्ट ऑफ द मार्केट होता है दैट विल बी अंडर डेफिशिट, क्योंकि उसमें प्रॉब्लम ये आती है कि आप जो है वो ट्रस्ट को ब्रीच कर रहे हैं, यू आर डिसीविंग द पब्लिक. तो वो एक बहुत बड़ा रिस्क बन जाता है. तो वी शुड नीड टू अंडरस्टैंड द रिस्क एसोसिएटेड विद ऑल द फैक्टर्स. और फिर अल्टीमेटली बीइंग चार्टर्ड अकाउंटेंट्स हमारी जो रोल बनता है वो क्या होता है कि गाइड करना कि कैपेसिटी को किस तरह से बिल्डअप किया जाए. जाहिर बात है मर्जर्स के काम होने हैं, एक्विजिशंस के काम होने हैं, तो उसमें जो कैपेसिटी बिल्डिंग होती है दैट इज टू मच रेलिवेंट फॉर अस, जिसमें हम क्लाइंट को गाइड करते हैं कि यू कैन हैव अ स्टीयरिंग कमेटी, जिसमें आप स्टीयरिंग कमेटी बनाएं, उनको कहें वो प्रॉपरली इसको ओवरसी करें, जिसमें हर एस्पेक्ट को ओवरसी किया जाए. लीगल एडवाइजर्स की काफ़ी हेल्प ली जा सकती है, उनसे उनकी इंगेजमेंट के साथ हम उसको मैनेज कर सकते हैं कि किस तरह से हम अपने लॉज एंड रेगुलेशन को कंप्लाई विद कर सकते हैं। अलॉन्ग विद दैट इंटरनल ऑडिट फंक्शन जो होता है वो इसमें बहुत वाइटल रोल प्ले कर सकता है, क्योंकि मॉनिटरिंग का प्रोसेस इंटरनल ऑडिट फंक्शन के थ्रू होता है। मॉनिटरिंग के साथ फिर हम उनको ये गाइड कर सकते हैं कि ओवरऑल इसके फंक्शन को लीड किस तरह से करके हमने कंप्लीट करना है। तो इसमें जो अगर मर्जर की बात की जाए तो इट्स अ वेरी कॉम्प्लेक्स प्रोसेस जो स्टार्ट होता है विद डिफरेंट टाइप ऑफ नीड्स। उसके बाद उसमें डिफरेंट मैनेजमेंट की डिस्कशंस होती हैं।
And definitely we will come to that merger question again. So we can cover that and so definitely is the important चीज is कि अगर हम advisory कर रहे हैं and our primary role is to ensure compliance of our clients
And
with that
identify the risk as well.
exactly और उसमें अगर हम उनको advise करें हमें कुछ ही अगर खुद नहीं पता if we are better able to understand competition laws तो we will be in a better position to advise them कि like if there is one way to non-compliance, then there is another way to compliance that might be better and yielding higher profits. So thank you, Noshiban. So coming back to Rida once again with you. Fundamental rights की हम बात करते हैं और ये कहा जाता है कि that competition is the fundamental right. So और competition laws इसको किस तरह से incorporate करता है उस पर थोड़ा सा हमें guide करें.
So actually, it's slightly different. Basically, what are fundamental rights? Those are certain higher rights, and in the case of our jurisdiction, those are certain rights which are enshrined in the Constitution, and which are given a higher protection and a higher degree of importance. And any law which contravenes or infringes upon those rights are essentially unlawful and void and can be challenged. So basically, what our constitution guarantees is that subject to every qualification, every citizen shall have the right to enter upon any lawful profession or occupation and to conduct any lawful trade or business. Now, the important qualification is this. It's not an unfettered fundamental right. It is said that it is subject to qualification. The right basically is that I or you can conduct any lawful business. And lawful business means that even if I am in a dominant position, even if I am in monopoly, I can run or I can conduct my business. So then wouldn't then competition law essentially be curtailing that right? This is actually one of those things that is envisaged by the Constitution itself, in which that it says, firstly, that it's subject to qualification. And then the article goes on to actually say that it is that nothing in this article shall prevent the regulation of trade, commerce, or industry in the interest of free competition therein. So therefore, your businesses, your trades, etc., can be regulated by the relevant competition laws. So in that way, the Constitution gives recognition to the fact that, you can conduct lawful business, but yes, it needs to be regulated and it needs to ensure that it is competitive. And how our law does that is basically in the Competition Act, where we have put in, certain protections that A, you cannot abuse a dominant position, B, your mergers, etc., are subject to the oversight and of the Competition Commission and compliance with their various requirements. 3, that you cannot undertake deceptive market practices, and 4, there are prohibited agreements. And all of these are obviously, they're separate chapters of their own, which has already been elaborated upon in the presentation. So essentially, this is how it is given that kind of constitutional recognition.
Definitely. Thank you. And now moving on to Afshin. कुछ थोड़ा सा हमारे साथ share करें what particular or key regulatory tools that you have developed and been using successfully.
So interestingly, we have proper system, proper framework and codes in place. तो हमारा एक कोड है जिसे हम एडवर्टाइजिंग कोड कहते हैं. It's there. It's a very detailed document on our website also. हमारे पास mechanism ये है basically कि for member companies, we have a process. So if, for example, one of the member companies come up to us and they file a complaint against their opponent or their competitor, they would come up to us, they, register karenge wo complaint, and then we accordingly, according to the code of conduct, we have proper hearing, we have a proper committee set up. वो कमेटी पूरी डेवलपमेंट देखती है, इम्प्लीमेंटेशन देखती है, एंड देन ऑन द बेसिस ऑफ we have another document which is the protocol of dispute resolution, यानी कि ये disputed उसमें आ गया territory में, and how are we going to resolve this entire thing. So that goes into it, फिर वो protocol के through पूरा वो process होता है, hearing होती है, and then we come up with a decision. So interestingly, since the society was formed in 1996, we've been able to solve approximately 1,000 cases. And ये वो cases है कि जिसमें कोई भी party ने कभी भी disrespect नहीं किया. So they've lawfully accepted the decision. And that decision could be कि either, taking off air their communication or making amendments in the existing communication and then, re-uploading. So ये fortunately हमारा बहुत अच्छे से
And
it works.
Is this like what the laws and regulations? Is this code exactly what law says, or this is something beyond that? This is more than what law requires.
So we're not a regulatory body.
Yeah.
ठीक है. तो
But
हम
self-regulatory
self-regulate कर रहे होते हैं. तो fortunately हम अपने members के लिए काम करते हैं. तो member companies usually हमारे पास आती हैं.
उनको तो आपने accommodate करना है ना, जो कि अगर law कुछ कह
Interestingly,
रहे
मैं आपको
हैं,
बताती हूँ, एक हमारे पास केस आया था a few years back, and this was my first case because मैंने उस वक्त नया ज्वाइन किया था और मैं उधर पिच करने गई थी अपनी मेंबरशिप के लिए, एंड मुझे उन्होंने पेपर दिखाया कि हमारे पास ये आया है कि हियरिंग है आपकी, एंड बिकॉज आई एम नॉट योर मेंबर कंपनी, तो क्या आप हमारे साथ you'll be fair to us. तो मैंने बोला कि आप आए, we'll see. ठीक है, and this is a very fair process. And case resolve हुआ, the decision was made in favor of the non-member company. And seeing the fair process and everything, fortunately वो member बन गए थे हमारे. But obviously, but आप समझे ये 85% एडवर्टाइजिंग स्पेंड है, तो अगर हम इन्हीं को कंट्रोल कर लेते हैं, which makes a lot of multinationals हैं हमारे पास, big local companies हैं, people like Tapal हो गया हमारे पास, Lipton हो गया, Unilever हो गया, so these are all our member companies. Mostly इन्हीं के गिर्द घूम रही होती है सारी कहानियां. लोकल तो या तो मशरूम ब्रांड्स होंगी जो इन्हीं को धक्का दे रही होंगी, इन्हीं को वो कर रही होंगी, प्रॉब्लम कर रही होंगी. So there would be
perfect.
Yeah.
Thank you.
Then we also have some white papers on the website. So white papers, for example, white papers होंगे जैसे children को advertising करते हुए क्या, what you should keep in mind. So उस तरह के white papers बहुत सारे हैं. So it's a very
it's a kind of guidance for them, that if you want to opt or you want to comply with that, or what course of action you might take. That's definitely very helpful for the industry. Okay, Atif Saab, so coming back to you, since what are the challenges that petroleum dealers are facing, and how is competition laws you think that they are important and they are addressing those challenges?
In the first place, I think we should register a case against the government because they are promoting the smuggling. So around 20 million liters a day is coming from different sources. And we are losing business. We have spent around billions and millions of rupees on this industry. And our business is totally compromised. I mean, if I am selling 10,000 liters a day, because of this smuggling, that has turned to around drop to 2000, the sites which we have on highways and GT roads, they are getting the worst dent on their business.
So what you are saying that smuggling is something that is actually impeding the competition. Basically, it's a
Yeah.
kind of opposite of cartelization or something.
Secondly, again, I would refer to our main speaker. The punchline for us was the abuse of dominant position. We have a regulated business. Our margin or our profit, that is regulated by the government, and vice versa, the OMCs, they are also getting a regulated margin. They are encroaching in our margin in different shapes, like franchise fee, like fleet cards, like credit cards. I mean, you and me, anybody, we go to a hotel or a restaurant. If you use a credit card, they will give you a discount of 15%, 20%. Whereas, contrary to that, on our case, they will charge us 0.8%. So our total margin is 7.64 rupees a liter. So you can understand if 0.8% will be deducted as credit card charges, so what will we be getting? 1.25 rupees they are getting from us as franchise fee. So same, and the fleet card, which I think government functionaries must be using of different tile marketing companies, they are charging us 40 pesos a liter. So all our regulated margin, they are encroaching in that. And we are working on 1.5%.
So what you are saying is that unfair pricing, basically.
देखिए अनफेयर का ये है कि I'll just quote one example कि पेप्सी है या कोई और ब्रांड है, वो अगर मेरे सेलेक्ट स्टोर पे आएगा, he will provide me a cabinet AC, give me a credit, and on every bottle, he'll be getting his margin, and on the sale of every bottle, I'll be getting my margin. So now, there is all over the world, I mean, you are well-learned people, nowhere in the world, the margin of the distributor and the retailer is always there is a difference of 40-60. Retailer's margin is 60 and distributor's margin is 40. So in our country, it's the other way around.
So what do you think that how competition law is actually helping you out? So if we can draw that relevance, so we can better understand. Definitely, this is not the forum. Government को तो नहीं हम उससे कह सकेंगे, but definitely competition law is here. तो वहाँ से अगर आप कोई relevance draw करके उसको relate कर सके, तो that will be more useful for us.
Definitely जी, मुझे तो बहुत कुछ आज की जो इसमें से बड़ी hope नजर आई है, और इंशाल्लाह will definitely approach और माशाल्लाह जो figures statistics दिखाए हैं इन्होंने कि अथॉरिटी भी है और डेफिनेटली आप लोगों की भी मदद लेंगे, और मैं आई वुड रिक्वेस्ट यू कि इन चीज़ों के ऊपर जो हमारे बर्निंग इश्यूज हैं, काइंडली इसको दोबारा इनकरेज किया जाए, जो कि आहिस्ता आहिस्ता अपना फेड होते जा रहे हैं, कि जो नेशनल क्राइसिस है हमारा एनर्जी का है, इसमें सेमिनार्स कराएं, जो आपकी असाइनमेंट्स हैं स्टूडेंट्स को आप वो दें, सो दैट के जो फ्रेश माइंड के साथ यंगस्टर्स जो हैं वो इनपुट हमें दे सकें, एंड दैट विल बी अ नेशनल.
Definitely, this is a significant factor for our economy. और बहुत से हमारे इकोनॉमिक इंडिकेटर्स आर डिपेंडेंट ऑन इट. सो डेफिनेटली उसमें हम वी विल लुक इनटू इट. So Norshaman, so back to our core topic, which is hot topic for chartered accountants के जब हम mergers or acquisition की बात करते हैं, and those activities are have been very prominent in the past. अभी कुछ economic slowdown से has been slowed down, and again we expect that a lot of activities are going to happen very soon. So would you like to share how the core aspects of competition law are now being evaluated as part of due diligence, and what is its relevance, and क्यों competition law वहां पे आ जाएगा, किस किस step पे हमें उसकी जरूरत पड़ेगी in the
Surely इसमें फर्स्ट ऑफ ऑल जहाँ से मैंने वैसे कंक्लूड किया था वहीं से स्टार्ट करता हूँ.
That's what I told you.
So basically there is a process of the mergers or acquisition which is basically start from the need assessment. और उसमें आपकी जो एक डिसीजन मेकिंग प्रोसेस होता है वहाँ से सिचुएशन चलती हैं. उसके बाद डिसीजंस के बाद लेटर ऑफ नॉन बाइंडिंग लेटर ऑफ इंटेंट एक इशू किया जाता है विद द बोथ पार्टीज जो उस पर एग्री करती हैं. अब लेटर ऑफ इंटेंट बेसिकली टर्म्स एंड कंडीशन ऑफ द मर्जर्स के बारे में बात होती है कि उसमें हम किन बेसिस पे हम मर्ज करने जा रहे हैं, मार्केट किस तरह से हम लेके आएंगे, प्रोडक्ट्स को किस तरह से हम मैनेज करेंगे, ओवरऑल जो ट्रांजैक्शन को किस तरह से हम गो थ्रू करेंगे, मार्केट के ओवरऑल किस पर्सपेक्टिव में चीजें जाएंगी. तो लेटर ऑफ इंटेंट जो होता है वो एक बेसिक सोर्स डॉक्यूमेंट होता है स्टार्टिंग पॉइंट ऑफ व्यू से. तो जब वो लेटर ऑफ इंटेंट की डेवलपमेंट की बात होती है तो वहां पे भी वी हैव टू सी ऑल द फैक्टर्स कि कहाँ पे एक डोमिनेंस क्रिएट हो रही है, लाइक मार्केट शेयर की फॉर्म में डोमिनेंस क्रिएट हो रही है या प्रोडक्ट की जो कैटेगराइजेशन के अंदर डोमिनेंस क्रिएट हो रही है. तो वी हैव टू एनालाइज ऑल दोस फैक्टर्स एंड रिस्क एसोसिएटेड विद लेटर ऑफ इंटेंट. सो व्हेन द लेटर ऑफ इंटेंट इज बीइंग मेड, उसके बाद फिर उसमें एक रेगुलेटरी प्रोसेस स्टार्ट होता है जिसमें कुछ अप्रूवल्स के पॉइंट ऑफ व्यू से एससीसीपी से कुछ अप्रूवल्स रिक्वायर्ड होती हैं, एंड सम टाइम उसमें कुछ एनओसीज रिक्वायर्ड होते हैं फ्रॉम द बैंक्स एंड लेंडर्स एंड द क्रेडिटर्स. अलॉन्ग विद दैट कंपटीशन कमीशन ऑफ पाकिस्तान का भी रोल उसमें इनिशिएट हो जाता है. तो लेटर ऑफ इंटेंट की बेसिस के ऊपर जो कंपटीशन कमीशन ऑफ पाकिस्तान होता है इनको एक एप्लीकेशन फाइल आउट करनी होती है. वो एप्लीकेशन फिर एक प्रोसेस में आ जाती है, लेकिन जो मर्जर का प्रोसेस होता है ये चलता रहता है क्योंकि इट मे टेक सम टाइम. उसमें फर्स्ट फेज होता है, फिर सेकंड फेज होता है, और फिर उसके बाद उसमें कुछ रिजर्वेशंस होती हैं फ्रॉम द कंपटीशन कमीशन. तो वो जो रिजर्वेशंस फ्रॉम द कंपटीशन कमीशन होती है दे कैन सॉर्ट सर्टेन डॉक्यूमेंटेशन एडिशनली कि हमें कुछ एडिशनल एग्रीमेंट्स की कॉपीज रिक्वायर की जा सकती हैं. समटाइम मार्केट शेयर के ऊपर जो एसोसिएशंस होती हैं उनकी रिपोर्ट्स रिक्वायर कर ली जाती हैं, या कुछ और इंटरनल जो बोर्ड की मीटिंग्स होती हैं उनके कुछ डिसीजन मेकिंग प्रोसेस में कुछ एक्सट्रैक्ट्स वगैरह होते हैं, उनकी रेलिवेंस रिक्वायरमेंट्स को रेज किया जाता है. तो वो सारी चीजें जब हम बना रहे होते हैं तो वी नीड टू अंडरस्टैंड द रिक्वायरमेंट ऑफ कंपटीशन कमीशन ऑफ पाकिस्तान, और उसको अकॉर्डिंगली हमें हर डॉक्यूमेंटेशन के अंदर उसको इंक्लूड करना होता है. लाइक मार्केट शेयर का क्या प्रोपोर्शन रहेगा ओवरऑल, या ओवरऑल डोमिनेंस के पॉइंट्स में से बात की है. तो ये कुछ चीजें हमें वहां पे देखनी होती हैं. फिर जैसे जैसे प्रोसेस गो थ्रू होता है फिर उसमें जो फेजेस की मैंने बात की, तो फेजेस में जो रिक्वायरमेंट रेज की जाती हैं फ्रॉम द रेलिवेंट अथॉरिटीज उनको फिर अकॉर्डिंगली हमें सेट आउट करना होता है, उनको भी एक्सप्लेन करना होता है. क्योंकि जब तक कंपटीशन कमीशन ऑफ पाकिस्तान अपनी उसमें अप्रूवल नहीं देंगे, उसमें समटाइम ब्लॉक एग्जामिशंस होती हैं, समटाइम स्पेसिफिक एग्जामिशंस होती हैं, तो जब तक एग्जामिशन नहीं मिलेगी आपको उस रेलिवेंट क्लॉज की या रेलिवेंट मर्जर की या उसके ऊपर अप्रूवल नहीं मिलेगी, तो उस वक्त तक आप अपने प्रोसेस को आगे कोर्ट में जाके प्रेजेंट नहीं कर सकते. इवन जब कोर्ट में प्रेजेंट कर देंगे तो प्रेजेंटेशन के साथ फिर कुछ रिक्वायरमेंट होती है, लाइक एससीसीपी की अप्रूवल रिक्वायर्ड होती है, कंपटीशन कमीशन ऑफ पाकिस्तान की अप्रूवल रिक्वायर्ड होती है, एनओसीज रिक्वायर्ड होते हैं. तो जब ये कंप्लीट डॉक्यूमेंटेशन आती है तो फिर ही ये प्रोसेस आगे चलता है. तो इट्स ओवरऑल प्रोसेस जहां पे हमें हर फैक्टर को अकॉर्डिंगली देखना होता है.
Is there any law of the timelines कि कितने time में competition commission has to come back, या normally कितना time लगता है?
30 days, I think so. 30 days, initially 60 days, and second review will 90 days, I think so. फर्स्ट फेज होता है वो 60 days में कंप्लीट होता है. उसके बाद अगर रिजर्वेशन हो, कुछ पॉइंट्स हो, तो फिर उसमें एक सेकंड फेज रिव्यू होता है. तो सेकंड फेज रिव्यू का 90 days के अंदर आई थिंक सो डिसीजन होता है. बेहतर आई थिंक सो वो टोटल भी 90 बन जाते होंगे. 60 वो 90 की बात कर रहा हूँ, सेकंड फेज की बात कर रहा हूँ. तो 90 वर्किंग डेज उसमें इनको रिक्वायर्ड होते हैं, इसमें इन्होंने
So
फॉलो
first phase में 30 working days.
लेकिन इसमें जो इंपॉर्टेंट बात होती है वो क्या कि जो रिजर्वेशन, जो पॉइंट्स, जो इश्यूज रेज किए गए हैं उनको आपने प्रॉपर्ली
हाँ,
अकोमोडेट
exactly.
करके
Oh,
निकालना होता है. लाइक रिव्यू प्रोसेस जैसा से होता है वो.
अगर रिस्पॉन्स ही नहीं दिया तो 30 days काउंटडाउन तो नहीं शुरू हो गया so it's always with
नहीं, ये तो हमारी हमारी नीड है ना कि हमने कोई काम करवाना है, तो
Exactly.
वी आर ईगर टू वर्क वेरी फास्ट, उसमें
Yeah.
हमारी रिक्वायरमेंट्स होती हैं, तो हमें इसको
Certainly.
एज फास्ट पेस काम करवाना होता है.
Certainly. So, coming back to Rida, जिस तरह से अभी e-commerce and digital economy is facing up, उसके अपने challenges हैं, उसके अपनी opportunities हैं. So, do you think that competition laws has to be amended according to the changes that are taking place with respect to, e-commerce or digital platforms and
Certainly. So I think this is a very large area and we can have a seminar in itself on this area. But to just briefly summarize, I think the fundamentals of competition law, which would be applicable to digital platforms and big tech, those are already there in the law. It's a matter of so the foundations are there. It's a matter of tweaking the regulatory framework in a certain manner that it contemplates digital platforms as well. Because look, there are certain problems with digital platforms which do not exist with other conventional industries. How do you define the relevant market? Sometimes it is difficult to define what is the service that this platform is providing. And then, your traditional, concepts that are applicable to mergers, for example, which you think that, okay, if you follow this checklist and if you satisfy this criteria, then you will be deemed, you won't be deemed anti-competitive. That sort of is different for big tech. So for example, there are a lot of killer mergers in big tech where I think Google acquired about 168 smaller tech companies just to kill off competition. Now on the face of it, they might be acquiring a company which is not viewed as a consolidation to create a dominant position or lead to any anti-competitive practice, but in the longer term it is actually leading to lesser competition in the market because they nipped it in the bud, they killed it from the start. So that's certainly a problem that you need innovation to catch up with big tech because they are innovating at a very rapid pace, and I think regulatory framework is not catching up with that speed. So yes, there is definitely room for improvement. Internationally, now we have the Digital Markets Act that has been introduced in the EU, and it specifically identifies gatekeepers, which are the big tech, like the likes of Facebook, Microsoft, etc. So I think that innovation needs to be across the world. But the bigger challenge, one of the biggest challenges, is implementation and creating deterrence. How do you stop big tech? So because they're always going to be ahead of you, considering the technology they have, the data mines that they have. So that's
but I don't know from the Pakistan market perspective, because we are not mature in any of the markets. I must say there are very few that they are mature. So do you think that that draws any relevance for the market?
Of course
Pakistan
it does, because this is the problem that's prevalent, that the law was late in catching up. So if we have that kind of gap right now, we need to plug it before these e-commerce or digital.
Or you may say that this is actually required to mature them, or to
I
actually.
think the law should precede the problem as opposed to the problem occurring and then the law innovating to sort of plug that gap. So I think now is the time to
Sure.
think.
So
If I may add, Mara. So when I was talking about platforms worldwide, and this I'm talking about entire world. कोई organization, कोई society where अभी तक they're unable to control Googles of the world, Facebooks of the world, और उनके साथ काम करना बहुत मुश्किल है because
they're actually controlling the economy.
Giants now. They know how to maneuver their ways. And उनके साथ वाकई में प्लेटफॉर्म्स के साथ, and I'm not talking about हमारी डिजिटल, उसके अलावा भी अभी तो आप देखें हमारे पास एडवर्टाइजिंग हुई, लेकिन अगर प्लेटफॉर्म एडवर्टाइजिंग की बात करते तो इट्स स्टिल दुनिया में कहीं भी उनको कंट्रोल करने का कोई लॉ बना नहीं. स्ट्रगलिंग हो रही है.
So we can safely say Pakistan to phir definitely that follows, but definitely we have actually developed some of the benchmarks for the regional or the developed economies. Um, so Afi, with regard to deceptive marketing practice challenge or the practices which is always been a very core to my heart, और क्योंकि ये काफी interesting होता है which affects every one of us basically. So do you think that there is a required level of awareness among the marketers and content developers on competition law and resultant implications for an undertaking if there are any violations? और उसपे मैं थोड़ा सा और भी इसको एक स्टेप और आगे लेके जाऊं, तो अगर ये वायलेशंस होती हैं तो किस किस्म की पेनल्टीज इंपोज होती हैं? व्हाट इज द क्वांटम? क्या वो पेनल्टीज आर इनफ to curb these practices?
Yeah. So when we talk about marketeers, हमारे पास दो तरह के marketers हैं. एक हमारे पास है multinationals. So multinationals के अपने legal frameworks बहुत strong हैं, ठीक है? And they know about deceptive marketing. अब फिर हम आते हैं local बड़ी companies के की बात करते हैं. So वहाँ पे भी legal framework शायद इतने strong नहीं है, लेकिन marketers को फिर भी पता है. फिर हम आते हैं एक टियर डाउन मार्केटर्स का आते
वहाँ
हैं.
पे भी होते रहे हैं ना, जैसे सेफ कार्ड के एग्जांपल हम लें तो वहाँ पे भी कंपटीशन
But they know about deceptive marketing. It's just they cross that line. They know about the law, but in marketing their product, they just go overboard.
Okay.
जिससे कहीं कहेंगे.
सही.
तो और कुछ चीजें मार्केटर्स हम लोग
That was
को
an
शौक होता है
informacy.
कम्युनिकेशंस बनाने का, और हम छोटे से डिस्क्लेमर्स भी डाल देते हैं
हाँ,
और वो
selling
सब कर
that.
लेते हैं जस्ट टू सेव आवर सेल्स. सो हम इसको इस तरह टियर वाइज करते हैं कि हमारे पास, हमें पता होता है टॉप टियर को यूजुअली पता होता है, स्पेशली मल्टीनेशनल्स एंड लोकल बिग ब्रांड्स. फिर जब हम आते हैं थोड़ी लोकल कंपनीज में और थोड़े से टियर डाउन, यानी कि थोड़ी छोटी कंपनीज होंगी, दे डोंट नो अबाउट डिसेप्टिव मार्केटिंग. सो दे वुड मेक मार्केटिंग कम्युनिकेशंस, दे वोंट नो अबाउट व्हाट इट्स देयर. फिर हम एक सेकंड टियर पे आते हैं विच इज दी एडवर्टाइजिंग एजेंसीज. तो ये मार्केटर्स जाएंगे एजेंसीज के पास और ये कम्युनिकेशन बनवाएंगे. एजेंसीज
असल रोल तो फिर वहां पे आएगा ना, जो
बिल्कुल, एंड दे डोंट नो एनीथिंग अबाउट डिसेप्टिव मार्केटिंग.
सो देयर इज अ प्रॉब्लम.
सो वहां पे भी एक प्रॉब्लम लाई करता है. एंड समटाइम्स ये होता है कि मार्केटर्स दे टेक दैट इनिशिएटिव और वो एजुकेट करते हैं एजेंसीज को, बट देन स्पेशली दीज कंटेंट क्रिएटर्स, अब आप देखेंगे कि अब कंटेंट क्रिएटर्स आपको इन्फ्लुएंसर्स, कंटेंट क्रिएटर्स या आपको डिजिटल वर्ल्ड में बहुत नजर आएंगे.
एग्जैक्टली.
They don't know anything about deceptive marketing. They would go to any edge to promote the brand. तो yes, we do face problems. और implications के बारे में तो कई दफा पता ही नहीं होता है. होता क्या है कि वो टीम बना लेती है कम्युनिकेशन. हमारे पास बहुत दफा केसेस आते हैं कि टीम ने कम्युनिकेशन बना ली है, बट ये मसला आ रहा है. So we kind of तो implications क्या है कि आपको obviously not only time आपका consume होगा for this hearing which may last to 90 days, but also उसमें financial loss भी है, because you need to get a lawyer on board, आपको सारी traveling करानी है, hearings पे भेजना है. So हम usually इसी तरह educate करते हैं कि rather than going
on to that hearing and incurring cost. So penalties की क्या quantum होती है? What is the
So हमारे पास यूजुअली जो केसेस आते हैं वो बहुत इनिशियल स्टेज पे आ जाते हैं कि जैसे ऑन एयर हुआ कोई चीज
तो आपने
और कंपेटिटर ने, अच्छा, सो वी आर नॉट अ रेगुलेटरी बॉडी, तो हम सुमोटो नहीं करते हैं. ऑब्वियसली जब हमारे पास कंपेटिटर आएगा या
कंपेटिटर एक्चुअली उसको रेज कर देता है,
वो यूजुअली वही रेज करते हैं. और अब एक बड़ी अच्छी चीज है जो मैं आई थिंक आई वुड, so हम कहते हैं कि the total function of our code is to complement, not to replace the law of land, and the law of land is CCP. तो हम कहते हैं हमारा कोड जो है उसको complement करता है. तो rather than वो आके आपको रेगुलेट करे, self regulate.
Definitely नहीं, this is a very great step, and definitely CCP के लिए भी एक बहुत बड़ी support है कि a lot of things और compliance वहाँ पे ensure हो रही है. So आतिफ साहब आपसे अगर हम next question करें और जिस तरह आपने बताया कि or we all know that this is a very significant sector for the economy. So how is your association playing the role in coordinating with the regulators like CCP and OGRA? तो ओग्रा के साथ तो मेरे ख्याल से बहुत बड़ा पंडोरा बॉक्स खुल जाएगा. So let's restrict to CCP.
The worst role is played by the OGRA.
मैं वही से इसलिए मैंने कहा कि
Unfortunately,
CCP पे
they are
focus
the
करें.
regulators. They are supposed to look after the supplier, the wholesaler, the supplier, and the end consumer.
Hmm.
But unfortunately, they are only and only protecting the OMCs.
तो बताएं ना सर, SCCP का
तो
बताएं ना.
अच्छा, दूसरा एक आपने
Competition
भी
laws किस
अभी
तरह से?
अभी आपने एक बात की कि इनको लॉस को चेंज होना चाहिए या नहीं होना चाहिए. तो मैं आई वुड लाइक टू कमेंट ऑन दैट कि देखिए, इट्स अ स्मॉल ग्लोबल विलेज लॉ. बिजनेस मॉडल्स आर रैपिडली चेंजिंग और हमें डे टू डे ग्राउंड रियलिटीज को अनफॉर्चुनेटली हमारे बाबू जो है वो एयर कंडीशन कमरों के अंदर बैठ के और लॉस बना देते हैं और सारी चीजें बन जाती हैं जिनका ग्राउंड रियलिटीज के साथ कोई ताल्लुक नहीं. इन द फर्स्ट प्लेस. सेकेंडली, आप देखें कि 1.5 रुपीज अ गैलन होता था. दैट टर्न्स टू बी 4.5 लीटर्स.
सही.
So now the oil price is around 300 rupees a liter. और जो हमारे प्रोटेक्शन लॉस हैं वो 1937 के. अभी तक किसी ने जहमत गुजारा नहीं की कि उनको देखा जाए, उनको चेंज किया जाए. लाइकवाइज आपने कहा था कि किस तरह कंपटीशन कमीशन इसमें इंटरवीन कर सकता है. एक और मेरा ख्याल है इधर से भी किसी ने बोला जी कि बड़े स्ट्रॉन्ग है रेगुलेशन जो मल्टीनेशनल है. हमारी मल्टीनेशनल हमारे रंग में वो जो है ना वो आ गई हैं. जब प्राइसेस बढ़नी होती हैं तो सिस्टम डाउन हो जाएगा, वो कैपिंग शुरू कर देंगे. ठीक है. और जब आप प्राइस कम होनी है तो फिर आप विदाउट डिमांड वो आपकी सप्लाईज जो है ना वो आनी शुरू हो जाती है. सो जो मल्टीनेशनल है उनका भी अल्लाह ही हाफिज है. पाकिस्तान में आके सारे एक जैसे हो जाते हैं. और दूसरा जो बेसिक चीज आपने कही है कि कहाँ पे इंटरवीन करेंगे ये, आप ये देखें कि जो फ्रेंचाइज एग्रीमेंट है बिटवीन द डीलर एंड द ओएमसी, दैट इज मैंडेटरी कि उसको दैट शुड बी अप्रूव्ड बाय द कंपटीशन कमीशन ऑफ पाकिस्तान. Now 35 OMCs are working. किसी ने भी शायद एक का सुना है किसी OMC ने अप्रूव करवाया. बाकी 34 जो OMCs है हमारी ऑयल मार्केटिंग कंपनीज इंक्लूसिव ऑफ मल्टीनेशनल, अब तो मर्जर भी हो गया माशाल्लाह. किसी का सऊदी अरेबिया से हो गया, किसी का कुवैत से हो गया. बट दे आर फॉलोइंग द सेम प्रैक्टिस विदाउट getting approval from the Competition Commission of Pakistan. They are forcing us to sign the agreement.
Okay. चलिए अभी कुछ और उसमें फर्दर डिटेल्स में भी बात होगी. So now we are going to conclude our session. Our last question, compliance के point of view से हम करना चाहेंगे. One from Rida, so try to be as brief as possible, and then Noshirwan, and then we would like to invite on stage Salman Saab and Ahmed Saab to come up on the stage. और कोई questions है हमारे तो हम उस पे फिर we will move on. So from the compliance, how the legal fraternity can ensure compliance with competition laws?
So lawyers, in particular corporate counselors like ourselves, we need to be very, very well versed with the competition law, because I'll tell you what happens. Mostly when clients come to us, they don't come to us with a competition concern. it is basically a corporate transaction in which we identify competition concerns. So for example, a company will come to us, and I think it's a recent application, the CCP is also approved and it's public, so I can name it. So Shifa, for example, wanted to do some group restructuring. They wanted to, get shares in its subsidiary. They came to us with a transaction. We identified, look, it's a competition concern. You meet these specific thresholds, merger thresholds. You have to file a pre-merger application with the Competition Commission of Pakistan. So knowing the law, knowing that within a certain transaction, these competition concerns are being triggered, and then educating the clients and their financial consultants with respect to them is a very important role. I'll give you another example. We do commercial agreements, and in those agreements, what was talked about today, these prohibited agreements. Those prohibited agreements are not very, like, they're not on the face of it. It's the substance. So who identifies the substance? It's the lawyer. So
Definitely.
we look at the clause
Advice
and,
में जब आ
and we
जाएंगे.
tell them, look, this is falling within section 4. You need to go for an individual exemption for this particular, clause. So that is one role that we perform. The other is, yes, the client is aware that this is a competition concern. Can you help us file the application, etc.? So we prepare the application, we submit it to the CCP, we liaise with the CCP, we answer the queries, we act as the go-between between the client and the CCP and translate each party's concerns to the other. So that's a very important role we play. And then the most obvious role is that if there is any, inquiry or a show cause notice, etc., then, people come to the lawyers and they ask, to draft a response, to represent in front of the CCP, etc. So that's how
Definitely, we know that lawyers are, a kind of, a big support in complying with all the
Yeah.
laws and
Yeah.
regulations. So, Noshirban, same question with a different aspect. So we want you to keep a hat of, ICAP, since you are a member. So what do you think that ICAP can play a role in empowering your members to assist them to ensure compliance with competition laws?
देखें इट्स क्लियरली एविडेंट आप लोगों ने ये आज इवेंट किया है, तो ये तो
बस मैं यही चाह रही हूँ ना, तारीफ कर दें आप हमारी।
तो आप लोगों ने देखें माशाल्लाह इवेंट मैनेज किया, एंड दिस इज द इंडिकेशन यू आर जस्ट वांटेड टू इंश्योर कि लोग इस कंप्लायंसेस को फॉलो कर लें। सेकंड थिंग इज कि समटाइम जो रेगुलेटरी बॉडीज होती हैं, दे कैन प्ले अ रोल। लाइक अभी IFRS 18 जिस तरह से आ रहा है, तो उसमें डिस्क्लोजर की रिक्वायरमेंट्स भी ऐड हो रही हैं। तो डायरेक्टली तो कंपटीशन से रिलेटेड नहीं है, लेकिन अगर कोई एक्सपेंसेस आपने कंपटीशन से रिलेटेड किए हैं तो शायद उनको भी डिस्क्लोज करने की रिक्वायरमेंट होगी। आई एम नॉट श्योर, मैंने जस्ट एक आर्टिकल पढ़ा था तो मैं उसको यहाँ पे रिफ्रेश कर रहा हूँ, तो मुझे ओरिजिनल IFRS 18 को देखना पड़ेगा, लेकिन उनकी तरफ से एक रिक्वायरमेंट आई है डिस्क्लोजर की। तो जब आप डिस्क्लोज करेंगे इन्फॉर्मेशन को, तो इन्फॉर्मेशन विल बी द पब्लिक, और जब पब्लिक पास इंफॉर्मेशन होगी तो वहां से अवेयरनेस ऑटोमेटिकली इंक्रीज होना शुरू हो जाएगी। आपको पता होगा कि ये कंपटीशन से रिलेटेड आपके एक्सपेंसेस हैं,
सही है।
तो आप उसको किस तरीके से देखते हैं चीज़ों को। सेकंड थिंग, सेशंस करवाए जा सकते हैं इसके ऊपर, इसमें वर्कशॉप्स करवाई जा सकती हैं, लाइक कंप्लायंस की चेकलिस्ट तैयार की जाए, मतलब जिसमें हमें हेल्प आउट कर सकते हैं जो कंपटीशन के कमीशन के जो लोग हैं, उसमें कुछ परफॉर्मर्स बना के वो रिप्रेजेंट किए जा सकते हैं। जनरल मिस्टेक्स क्या होती हैं एप्लीकेशन फाइल करते वक्त, या बाद में उसमें जो रिस्पॉन्सेज आते हैं उसमें क्या इश्यूज होते हैं, और चैलेंजेस जो फेस करने पड़ते हैं कंपटीशन कमीशन ऑफ पाकिस्तान को, वो क्या होते हैं। तो जब उसके बारे में हमें इंफॉर्मेशन होगी तो वी विल बी इन बेटर पोजीशन टू गाइड आवर क्लाइंट्स कि हमें किस तरीके से कंपटीशन कमीशन ऑफ पाकिस्तान को डील करना है, क्योंकि ये डील बड़ा एक इंपॉर्टेंट मैटर होता है, क्योंकि उसके बगैर हम अपनी एप्लीकेशन थ्रू नहीं करवा सकते। तो फिर इसके कुछ अपने प्रोटोकॉल्स होते हैं जिसमें इनकी इन प्रोसेस एप्लीकेशन के वहाँ पे इनकी वेबसाइट पे डिटेल आ रही होती है, उसमें आप प्रोग्रेस को मॉनिटर कर सकते हैं। तो इस तरह के जो इवेंट्स हैं, आप जाहिर बात है जो लोग इसमें क्लियरली मर्जर्स के काम में या एक्विजिशन के काम में इंगेज हैं, वो तो इन कामों को देख रहे होते हैं, लेकिन क्योंकि ये एक एट पब्लिक एट लार्ज काम नहीं हो रहा था, पाकिस्तान वैसे मर्जर और एक्विजिशन बड़े लिमिटेड होते हैं, ज़्यादा होते नहीं है। सर ने बताया था कि कुछ आपके आगे जो मनी एक्सचेंजर्स के पॉइंट ऑफ व्यू से जो आना है, वहाँ पे कुछ एप्लीकेशन ज़्यादा ओवरवेलमिंग रिस्पॉन्स रिसीव हुआ है इनको। तो उसके अलावा ज्यादा जो चीजें हैं वो इम्पोर्टेंटली वही हैं कि रोल ऑफ द कंपटीशन कमीशन ऑफ पाकिस्तान एंड हाउ दे कैन इंक्रीज द कैपेबिलिटीज एंड कॉम्पिटेंस ऑफ द पीपल। क्योंकि हमारे पास एक लॉ एंड रेगुलेशन ही अवेलेबल है मेनली, तो या
डेफिनेट
कुछ परफॉर्मेंस अगर अवेलेबल हो जाएंगे, चीजें हो जाएंगी, तो हम बेहतर पोजीशन में होंगे उसको अप्लाई करने में।
चलें, the suggestions are well noted. So we will try to communicate to the competent authority. Now may I please request Salman Amin साहब on stage. अच्छा wrap up कर दे। चलिए, वैसे ऑनलाइन भी कोई ज्यादा क्वेश्चंस नहीं है एग्जैक्टली और लाइक अगर कोई क्वेश्चंस हैं few questions if we can sure ये यहाँ पे माइक दे दो।
ये हमारे प्रॉब्लम तो 76 ईयर से आ रही है और हम जानते हैं सब प्रॉब्लम का सब इवन कॉन्स्टिट्यूशन ऑफ पाकिस्तान 38 आर्टिकल है कि ये रियासत की जिम्मेदारी है कि दौलत चंद हाथों में ना याद रही साथ और पुराने टीम में है कई लाख या पूरा दौलत बाइनामा में आएगी सेम एक ही आर्टिकल, लेकिन एक सेकंड के लिए 76 सालों में किसी लीडरशिप ने इसको कैसे नहीं किया एक मोमेंट के लिए। अगर आपने कोई किताब किसी ने चंद रही साथों में दौलत घुसाए ना घूमे और ना चंद हाथों की मलकियत करना, मुझे बताइए कि 76 ईयर। और दूसरा एक और मैं चीज ऐड करता हूँ कि इलामा इकबाल ने किताब लिखी थी इल्मुल इक्तिसाद इकोनॉमिक के बारे में, शायद आपने ना पढ़ी और एक लाइन का उन्होंने हाल बताया और आइंस्टाइन ने भी उसी पे लेकिन इम्प्लीमेंटेशन भी हुई। तो आप उन्हें बताएं कि एक लाइन में इसका हाल भी है या दो लाइन में, फिर मैं आपको बताऊँ।
तो आई थिंक नेक्स्ट उस पे चलते हैं, अगर किसी के पास हल है तो बता दे।
दुनिया के लिए
बस मेरे हिसाब से कायदे आजम एक बात कह के बहुत अच्छी चीज कह के मरे हैं, इस दुनिया से गए हैं। यूनिटी पे उन्होंने कहा, तो मुझे नहीं लगता इस कौम में एक चीज जिसके लिए मैं हमेशा बोलती हूँ कि इस कौम में यूनिटी के अलावा सब कुछ है शायद। सो जहां हम जब एक प्लेटफॉर्म पे एक आवाज लेके खड़े होंगे तो शायद सामने वाला बहुत सारा उस वक्त विल बी एबल टू।
ये आप कार्टेल की बात तो नहीं कर रहे?
नहीं, मैं इंडिविजुअल एज एन इंडिविजुअल हम सबसे बात कर रहे हैं। तो वो जो कह रहे हैं ना कि कुछ लोगों के हाथ में ही है, सो आई थिंक दैट इट इम्प्लाइज टू, और खाली हमारे इंडिविजुअल नहीं कंपनीज के हिसाब से भी शायद हो सकता है इस तरह से, बट आई डोंट सी दैट।
सर मैं थोड़ा सा इस पे ऐड ऑन कर देता हूँ जी। इंपीरियलिज्म का जो सेकंड वर्ल्ड वॉर के बाद जो सिलसिला शुरू हुआ है, तो उसके बाद मेरा ख्याल है ये दुनिया ताकतवर की है। मेरा ख्याल है जितनी जल्दी हम इस हकीकत को कबूल कर लें, आई मीन जो एडवांस्ड कंट्री हैं, डेवलप कंट्रीज हैं लाइक अमेरिका एंड यूरोप, मतलब यूके की बात कर लें आप, एक ट्रेन जब ब्रुकलिन से चलती है या उस ब्रॉन्क्स से चलती है ना, तो उसकी आप शक्ल हुलिया क्वालिटी ऑफ पैसेंजर्स देखें, पर्सनालिटीज देखें, डिफरेंट होंगी। जैसे जैसे इट अप्रोचेस टुवर्ड्स मैनहट्टन, आपको ड्रेसिंग भी चेंज हो जाएगी, जो ट्रेन की क्वालिटी है वो भी चेंज हो जाएगी। तो हम तो अभी बहुत दूर बैठे हैं।
जी जी बिल्कुल, देखे ना, इसीलिए तो अब्यूज ऑफ पावर उन सब चीजों को करने के लिए कंपटीशन लॉज है, कंपटीशन सीसीपी इज देयर। सो चलिए सर कंक्लूड करते हैं। वी हैव अ डिनर, वहां पे हम बैठ के इस पे जो है ना वो
आने वाले दौर में 70 साल बाद ऐसी चीजें याद होंगी जो टाइम स्पेस से बाहर निकल जाएंगी। इंसान खुद ना निकले जमात से, जात से, पार्टी से, मुल्क से, कौम से, ये टाइम स्पेस है। मुशरक से लाख की लाख रुपए, यानी हम इसी में घूम रहे हैं, मेरा मुल्क, मेरी जमात, मेरा कुछ। लेकिन जो आर्टिफिशियल इंटेलिजेंस है वो इतनी आगे कर देगा, ह्यूमन इंटेलिजेंस तो पीछे ही आ रही है ना, और डिवाइन इंटेलिजेंस तो पता ही किसी को नहीं। और ये टाइम स्पेस से बाहर आएगी। ये इतना पॉपुलर है इमरान खान से भी ज्यादा, हर एक की डेट में और पॉपुलर भी है और साथ भी है और कूल भी है और कबूल भी है। और जो सुपर ह्यूमन इंटेलिजेंस जिसको कहते हैं ना, ये सिंगुलैरिटी है। और आइंस्टाइन ने भी यही बताया था कि इसके लिए टाइम स्पेस ना मशरक ना मगरब ना शुमाल ना जुनूब, और जो यूनिवर्सल लीडरशिप या ट्रांसह्यूमन होता है ना, उसके लिए भी ऐसे ही होता है ना, दिन ना रात। अगर हम अभी ये मसला हल करके नहीं उठते, ये 10 साल तक ऐसे ही चलता रहेगा।
सर इस पे
ये मसला ना
dinner-
वैसे अहमद साहब ने बड़ा अच्छा एक्सप्लेन किया था।
सारे यूनाइट हो गए एट द मोमेंट। अच्छा टाइम क्या है? टाइम फ्यूचर पास्ट प्रेजेंट नहीं है। द करंट एग्जिस्टेंस मोमेंट एग्जिस्टेंट लाइफ, जिसको लोग कदर भी कहते हैं, वही काबिल कदर बनता है। अगर उसको हम ग्रिप कर लेते हैं, जैसे साइंसदान कर लेता, वली कर लेता, तो हर वक्त काम करता है। अगर नहीं वक्त हाथ नहीं आया तो कुछ नहीं। तो वक्त के साथ स्पेस भी है।
सर हम खाना खाते हुए स्टमक भरा होगा ना, और ज्यादा अच्छी डिस्कशन होगी, तो एवरीबॉडी
आप ज्यादा बोलेंगी तो उन्होंने सारी डिस्कशन आपके साथ ही करनी है फिर।
इशू को थ्रू टाइम एंड स्पेस फोर्सेस जितनी भी है ना, उसके पास में होना, चाहे इबादत है, इसका हाथ करना है, हमने कोई शिरक का मामला है, क्या तो कोई भी किसी भी तरह का मसला है, तो टाइम स्पेस की सिंक्रोनाइजेशन उसको निकालना होगा एट द करंट मोमेंट। ये नहीं कल अभी, वरना सोना नहीं है ना उठना है।
So, Amara, I'll just
Sorry,
take
thank
5
you so
minutes.
much.
There's some one or two questions I'd like to
जी
ask. So there's one other proposal we will put forward to CCP, and especially taking the benefit that Salman is here as well. He already knows he's a chartered accountant in the auditing process, and will request CCP if they can give us some of their precious time. And as a practicing management committee, along with Zishan Jaz, we like to propose a kind of a checklist for our members for CCP. We will first make it ourselves, and even they can do it officially or unofficially. If they can review it, and then we can forward it to our members. So something concrete comes out of this event today.
Yeah.
And then we'll be able to disseminate to all our members, and during their audits of high profile clients, they can go to these checklists. For example, they can ask the board minutes if they have some competitive information or not, whether there's any likelihood that they have broken the laws or something. So this kind of action, if the CCP could help us with, so there'll be something concrete coming out of it. Apart from that, I think one issue I think you ladies should have brought it up regarding the deceptive marketing is, whenever you go to any sale, you will find in a Calibri 50 font written 50%, and a 10% you'll write the word up to written. Please take it up. This is a real deceptive marketing, that whenever you go and you'll find this small word up to written with 50 or 80%, you should go ahead with it.
इमोशनल डैमेज भी होता है।
वो जी बहुत ज्यादा emotional damage है, I think you should have taken it up. Another serious question I want to know, because keeping in view the real estate sector, normally when people buy a piece of land, etc., and at that point, people assume that they have paid for it. But technically, I just want to know whether it falls under the CCP Act or not. They do not get to know the development charges, and normally they are levied afterwards. That is something at a common problem. Does it come under deceptive marketing, or is it an industry-wide practice? What is the legal view on that? That's it.
ठीक है, सलमान साहब, would you like to answer?
Thank you,
will
Amara, and
take
thank
the
you.
seat.
Over. Thank you, Elisa, for highlighting these issues. I think the answering the first question which you mentioned is, when it comes to developing the checklist, obviously, as Emma Saab has presented, we have a guideline as well. So we have to give it a shape of a checklist. This we can work with ICAP, and ICAP has got very good technical teams. So just develop, and our team is there, and they can take the lead from the guidelines which have been developed. Number two, when it comes to the retail and these grocery stores, you took it very lightly. We take it very seriously because it's a question of law for us. And I must tell you that in UK as well as in Pakistan as well, this shelf description and what they display. And disclosure is something no one knows better than a CA what disclosure is. So, what disclosure requirements they are going to have, and whether they are, being deceptive or not. As was very clearly explained in that presentation as well, what is deceptive and not. So that is the area where, across the globe, the regulators are very serious. So that's a very serious matter, and that's a violation of law. And we are going to we are already taking very serious measure of it, because it impacts public at large. Third aspect you have highlighted about the real estate sector. I can certainly again inform you that I was part of that bench that took action against 88 housing schemes. 88 housing schemes, they were into fake practice. They were, not disclosing the terms of it, or, they were being deceptive that we have got the NOCs from LDA. And when we get into it, they were having just a letter from a union council. And, the society was launched somewhere very close to Multan, and it was saying that we have got the LDA approval. So, that sort of things happen. So, and way forward, what we are doing is we are already working. Even last week, there was a meeting, I could say public hearings were held, which was carried out by my colleague member, Said Saab. He's heading MIU, Market Intelligence Unit, and he has carried out, these public hearing along with district officials, just to ensure that people are not robbed of their entire life savings. So all these measures are already being taken.
Okay, so now we are concluding. Sir, lunch was for dinner pe kar le. So like it's already overrun. So Salman Saab, would you like to conclude? And then we would. And thank you so very much to all the panelists. Please take your seats.
Okay, the first thing is that we have not abused the dominant position. In ICAP, we had a forum, the panelists, which was not dominated by the CA professionals. So the first compliance has been done by ICAP, and CCP has ensured that compliance, that we don't abuse this dominant position. And the purpose is to have these stakeholders, highlight the issues, what they are really actually facing and handling as well. For example, Khwaja Sahab was talking about what the problem they are facing, even dealing with OMCs and multinationals, and they talk about compliance and corporate practices. And then obviously when it comes to, self-regulatory mechanism, we don't want to get unnecessary involved in over-regulating. We suggest and we promote and support self-regulation. If Pakistan Advertiser Society has, taken this initiative, look at how we are facilitating on it. And these forum, why this forum is very important and why we carry out these advocacy activities is, I just give you the example of 10 days back, what has happened. You all know there are certain requirements for the listed companies of releasing the material information to the stock exchange. And one listed company released this information to the Pakistan Stock Exchange that, we have agreed with our competitor that they are not going to conduct their business in northern part of Pakistan. And the CFO was there, the CEO was there, the company secretary was there, CFO was a chartered accountant, the company secretary was from legal fraternity. So, that is why we conduct this session. And when, I came to know about all this, I was discussing with Ahmed, improve your presentation. People does not understand your presentation. Otherwise, this violation should not have taken place. So I think his presentation was more enlightening for you today. So this was just an example. And concluding it, I won't be taking much of time because sir has to discuss something with Miss Amara over the dinner. So I won't be taking much of the time. So concluding it, thanks a lot, ICAP. Thank you, Zishan Saab. And Anil is not here. So this was the first time I was coordinating with Anil and Miss Amara. So Zishan Saab ke saath humne the काफी पहले coordinate किया हुआ है. And I would also like to thank the past president as well. Rashid Mir Saab is here. Ali Latif, ex-president, is also here. Makbul Saab, council member, and other council and NRC members are also here, and all respected, members who are here and online, whosoever is also there. I would like to again thank you, and I hope this session has justified the 3 CPD hours which you have earned very well. So thank you very much.
A heartfelt thanks to our skilled moderator for orchestrating the dynamic, informative panel discussion. And of course, a big thanks to our esteemed panelists for their valuable contribution and a very engaging discussion among the audience. So now I would like to proceed further. So today we are lucky to have a person who holds a 22 years of experience. He is not only a partner at not only a partner but also a head of office management at KPMG Lahore, and he is the vice president of ICAP. So please let's hear the address from the session chair. So please put your hand together and welcome none other than Zishan Ejaz. Over to you.
Thank you very much. Assalamu alaikum. I'm really honored to have finally this time. I think we are almost 30 minutes overrun. But the interesting part was the overall interest shown in the overall panel discussion and before that, the presentation. So I'm really honored to have past President Rashid Saab here, our seniors, my fellow council members, and one who is also the fellow council member and the ex-president. I was confused how to title that. I hope I've covered that. So a lot of things have been already covered. I'll just slightly touch upon what was the purpose of this particular whole engagement. Why chartered accountants need to have that particular understanding and everything. That has been touched upon by my fellow panelists. One was the compliance, the other was the risk management. There are a few other things I would like to highlight. One is the ethical standards. These are the ethical standards we as chartered accountants need to maintain. So how can we maintain that? We need to have that information and the knowledge to maintain that ethical standard. So CCP competition laws are important. Then another part was education and training. Those chartered accountants who are actually engaged in education and training, they need to understand, they need to disseminate those information amongst their students to be able to understand the competition law. Then obviously the merger and acquisition have already been touched upon. Then there is those advisors who are actually there and practicing, advising their clients on that. Then there is financial reporting. He touched upon the IFRS 18. In any case, not only from the perspective of IFRS 18, I'm not sure that is applicable or not, but when it comes to reporting standards and the auditing, if there is any requirement or a non-compliance or something, those have to be reported, and that has to be considered there. Ultimately, Rida rightly mentioned, we need to be collaborating with our other departments or colleagues like lawyers. So obviously we need to have a basic understanding. If we don't have that, how we are going to take it forward and jointly take things forward. Lastly, the most important part, I would like to really thank Salman. He's the driving force behind this thing. He has, thanks to him, special thanks to him, last 2-3 months, I have been really pain in his life, actually. But the good part is he has always been smiling, and he has been one of our fellow member, actually, who has given time like anything. He has been part of the CFO conference, and frankly speaking, I have heard a lot of positives and a lot of positive feedback about how he expressed his candid views during that CFO conference. And today also, we all are here. He is the one who managed to arrange most of the panelists. So effectively, credit goes to him and the NRC colleagues who are there and collaborating with Salman Bhai. And once again, thank you very much, everybody. Looking forward for a dinner. Thank you very much.
Thank you so much, Mr. Zidane Jaz, for sharing your thoughts with us. So now it's time to present a token of appreciation and remembrance to our distinguished guests. So for this, I would like to call Mr. Zishan Ijaz on the stage, Ms. Amara Gondal, please in your applauses, Mr. Rashid Rahman, please on the stage. Mr. Ali Latif and Mr. Makbul, please be on the stage to present the token of thanks to our guest speakers. I would like to call our first guest, which is Mr. Salman Amin. So please welcome Mr. Salman Amin. Mr. Ahmed Salman Amin, please be on the stage. Okay, sir, we will do it at the end of the meeting, so please, you can sit. Sir Salman. Okay, so our second speaker is Mr. Ahmed Kadir. So please welcome Mr. Ahmed Kadir. Now it's turn for our panelists. So I would like to call Mr. Nosherwan Khaja. Please welcome Mr. Nosherwan Khaja. Our next panelist was Ms. Rida Aslam Bhatti. Please welcome Mr. Rida. The next panelist is Ms. Afshin Rizvi. Please welcome Ms. Afshin Rizvi. Our last panelist was Mr. Khaja Atif. Please welcome Mr. Khaja Atif. Thank you so much all for giving a token of thanks to our guests. You may be seated. Mr. Zishan Ijaz, please stay on the stage. Mr. Salman Amin wants to present his gift. So now I would like to call all the panelists and the council members to be on the stage for a group photo.